All right, Lyric Armstrong, real estate agent and advocate. We're going at this a second time. So hopefully this take is better. Bottom line is we're back at the YSL Young Thug RICO trial. And we're actually on the one that's actually in trial right now. We have kind of touched upon some pre-trial motion. This is the one that actually deals with Mr. Jeffrey Williams, been Brian Steele, and crew. Okay, so Judge Glanville, we had a lot of great details as to what the ex-party meeting would look like it was about based upon the motion to recuse and the affidavit by Weinstein. We did that in the ex-party detail video, so check out all of those details. We actually went through and did a little research, saw what the professional code of conduct stated, what comment 5 was about, which is what Brian Steele kept asserting to the judge that this is the most pertinent part, and therefore he could not reveal his source. The judge was trying to find out who is the snitch, just judicial mob stuff, whatever. Well, if you've been paying attention between then and now, so many things every day, all day, there's something different and new. Madam Attorney, I believe it's Kayla Bumpus, is the attorney or was the attorney for Copeland during this time frame. Consequently, she has done a couple of interviews where she exposed that she was not the informant as much as Judge Glanville tried to allude to. It must have been her. She must have told she was not the informant as to there was an ex parte hearing. In fact, her involvement was kind of like, just on a whim. She walked in for a regular hearing and they would call her over and said, come on to judge's chambers. She went to judge's chambers and no one expressed to her that it was a confidential meeting at any time. It was in his chambers. It became evident that the defense was not there. The conversation, of course, was in protection of her client, so she was focused to that. And there was a lot of in and out. It was formal and informal in some regard because there was a lot of in and out of different individuals. So she's been quoted as saying she did not know the meeting was confidential and she's not the original informant. In fact, Brian Steele, I keep calling him Ben. I mean, Ben Chu, you're in my brain, okay? But Brian Steele comes forth and approaches her and says, what was this meeting you guys had this morning? Like, I heard you guys had a meeting. What meeting was this? And so she proceeds to give him information, some information he already knew, and then some information he didn't necessarily know. But it was based upon one, that she did not know it was a confidential hearing, and two, there was no order for ex parte. So, like I said, you give notice that there's an ex parte hearing, the judge gives an order to the effect. I think this is kind of why he's saying, well, he's the one who asserted that it was an ex parte hearing. When Brian Steele starts quoting certain things about an email and an FU to this and who's appearing and not appearing, judge cuts him off and says, that was an ex parte. How do you know? So he informs them it's an ex parte hearing, but he never put an official order for it, so they didn't have notice properly prior to. And consequently, this is what Attorney Bumpus was saying, that she herself was uninformed and she was there to be representative of her client. And turns out, they had him in the chambers. So, and the other thing about having him in the chambers, we also found out that he was in handcuffs because he was held under contempt. And the reason for the contempt was relative to him pleading the fifth. And this is what I'm gleaming this from the interview that Bumpus did, because he pled the fifth while he had an immunity deal, but the immunity deal was given to him on Friday. So she confirms that the reason for the meeting was to go over the immunity deal to ensure that Mr. Copeland was informed of what his immunity was and what that agreement really entailed, and then what was required of him in performance thereof. And somewhere along the lines, it gets a little extra. So we're going to find out what extra looks like. We have the transcript, so we're going to get into the transcripts. Okay, so Fullerton County of Georgia, or Georgia. We just have to sip tea for that, because this right here, Fullerton County can't get nothing right. I don't care who you are or what you're talking about. You say Georgia, Fullerton County, and it's just nothing is right. Oh boy, just like this computer. All I did was okay, because I'm about to, oh my lordy. Okay. Will this one work? No, neither of them will work. This computer is doing weird things. Okay, I should stop trying, huh? Okay. I really just okay. Anyway, forget it. Stop touching it. So sensitive. Anyway, we salute ATL, all those is bringing ATL back. And we see that there's a lot to do. There's a lot to do, and Fullerton County is a starting point, I guess. So this was filed July 1st by the Fulton County Superior Court. This is a trial court in Georgia. They call it Superior Court. A lot of courts do. And the clerk is Alexander. So all clerk did was file it. Okay, so don't yell at the clerk about it. All they did was file it. Okay, now let's get into the motion. This case number. This is the actual transcript of the ex parte hearing that took place on June 10th in the chambers of Honorable Glanville. Okay, Miss Weaver is the court reporter. Okay, don't call these people. Please be respectful. Okay, appearance. The state was represented by ADA Love, ADA Hilton. So those were only representatives of the state, and Bumpus was in representation of the witness, Kenneth Copeland. So we maintain the biggest issue about the ex parte is that Copeland was a sworn-in witness before this happened. So that's one of the bigger problems. Okay, so ex parte, excuse me, that deserved a lot of tea because him being a sworn-in witness is what gives rise to the issue here. This is a critical stage within the case. This is the witness that the prosecution is hedging their bets on, that they believe most of the issues will center around this testimony, which is why I'm like, if you're gonna have testimony and you're gonna try people on a RICO case, why are you trying people on a case that you don't believe? I mean, for a witness that you cannot believe because he's told you he's a repeat offender of lies. And now we know they wanted to move forward with impeachment. So we've heard the hearing about that. That was in another video. Check it out. Let's get back into transcript. The hearing supposedly began around 9:10 a.m., 10 minutes after 9. Those who were present, of course, was the judge, the ADA Love was present, and Attorney Bumpus was present, the court reporter, and investigators, Antonio Long and Rashid Hamilton. So not sure, but to me, I'm still on the presence of the atmosphere. So there was an assertion, not an assertion, but Judge Glanville read one of the cases, and I don't know if it was the Adams case or not, but they cited that an ex parte of a witness would be proper if there was some type of threat to the witness. And so therefore it was a need to have a conversation with the witness ex parte because the party is threatening the witness or a loved one of the party is threatening a witness. Attorney Bumpus confirmed that there was no threat on the table. He didn't have fear for his life. He didn't have a feeling of being threatened. So that particular point doesn't really have relevance to this particular ex parte. But I tell you what is threatening, in my eyes and in my opinion, if I am going to be in the witness box, and I've had to be in the witness box, I've had to be in different places in the courtroom. I'm a paralegal, done that, but I've also had to be in the witness box. And the witness box in and of itself has a different feel to it. You perceive it differently than you do when you're sitting behind the desk of the defense, or when you're behind the front row, the first row in the well of the, I mean, not the well of the public. Every space gives a different feeling within the courtroom. Now you're in the judge's chambers. And that's what I said in my video. I feel like just the presence of being in the judge's chambers gives a different weight to the conversation. And that in and of itself can be coercive, or it can be intimidating to the witness. And now to say there were investigators who I'm sure he's kind of familiar with, these are the investigators of the case that are in the room. So you have all these people in the room with the judge and none of the defense counsel. So the defense counsel gives you the impression that there's something of both sides going on. The lack of the defense counsel gives you an impression that everybody here is in agreement. So that to me is highly prejudicial, because if the judge has them in chambers and you're giving the witness the impression that they all agree against your desire to plead the fifth, and they all agree that, they're on the same side of this argument, it may feel like they're on the same side of going after the defendant. And the judge is supposed to be impartial. I mean, going after, the defendants, and judge is supposed to be impartial. Representing a fair trial means you are impartial. So having the ex parte hearing with the witness can, just by context and by the layout of the scene, give a weighted, preferential tactical strategical advantage to whomever is there, whether it's defendant or the prosecution. At this time, it was the prosecution that was on the scene. We went over what the tactical advantage, what problems that presents for the judge. Once we find out more about the ruling, which I don't know how much we'll be able to trust it, but once we find more out about the other judge's ruling on the motion to recuse, we'll see where we are in Georgia. But like I said, who is going to rule against their boss and still keep their job? You know, if this is an attorney that he's the chief judge over, he assigns their cases to, he's a part of them having their job. I mean, how do you have impartiality to rule based on the facts? I don't know. All right, so we're ready according to court report. We're back on the scene. Ms. Love, thank you. The concern that we wanted to bring to the court's attention as the state is twofold. One concern, we wanted to have the opportunity to impress, what wording? We wanted to have the opportunity to impress upon Mr. Copeland with representation present that he faces. And we wanted to give him an opportunity to ask whatever questions he wanted to ask before he was we had to pull him in the courtroom when the jury came out. What a very inarticulate, I don't know. So just think about this. When you're speaking to someone, the conversation makes sense because you can make the tone, you can give the look, all of the extra add-ons in communication can really bring forth what you're trying to intend to communicate. But when it's paper and it's black and white, it doesn't always read well. Like, I don't understand this. We wanted to give him an opportunity to ask whatever questions he wanted to ask before he was we had to pull him in the courtroom when the jury came out. So I guess her statement is we wanted to inform him as to whatever rights he has and responsibilities he has because we're getting ready to go to court. They were supposed to be in court. So maybe that's what she's saying. Before the jury comes out, we want to talk to him and get on the same page. That's probably what she's saying. Problem I have is right off the bat, has the opportunity to impress upon Mr. Copeland. So that language right there can be concerning because it is to impress upon a person can be considered influential or to push an issue versus, look, these are your rights. Have fun. Which one do you want to take care of? So I wouldn't have, especially now in hindsight, because Ben Steele is saying not only was there coercion, but you also intimidated the witness. And to use the word, we want to press upon the witness. It's like, I just thought maybe they had the opportunity to inform the witness of all of his rights and responsibilities would have been a much better sentence versus impress upon. So anyway, the second concern that she speaks to is that this is still 80 Love, right? Yeah, I wanted to bring to the court's attention in line with the concern that I expressed on the record on Friday. I don't know what advice counsel may have offered or may be offering, that this is their right and their business. As it relates to testifying, however, I do not believe that criminal exposure is a concern. That is which in interest is being spoken about and protected. Okay. I don't know. So this really relates, the second concern that she's speaking of right here relates to the actual hearing where he invokes the fifth. And the fifth is, I have the right to not speak so that I don't further incriminate myself. And she's speaking, or, I don't have any criminal exposure. And so she's saying, I don't believe that he would have criminal exposure. So I'm not sure what his counsel has advised him is what she's alluding to, or I guess what she says, but obviously I won't know because that's attorney-client privilege. And then she goes, I guess Mr. Melnick relayed to Ms. Hilton on Friday that he had never heard of the statute. What are we talking about? 24,507, and this is Georgia, right? Was it 5 or 4? Yeah, it's okay. 5. Grant of immunity. Okay. So Melnick, if I get this right, was his original attorney prior to Bumpus. Georgia Code 24 privileges 24,507. Grant of immunity. All right. So this is I guess it deals with contemptuous. Okay, contempt. So let's see. Whenever in the judgment of the Attorney General or any district attorney, the testimony of any person or the production of evidence of any kind by any person in a criminal proceeding before a court or the grand jury is necessary to the public's interest, the Attorney General or the district attorney may request in writing the Superior Court to order such person to testify or produce the evidence. So this is where you can be ordered to testify or produce evidence because the information that you have in a criminal proceeding is highly pertinent, and it's to the judgment of the AG and the AG's district attorneys. So it's not necessarily the defendant's ability to say, I plead the fifth. This is a Georgia's statute or code that says they can order you to testify. Upon the order of the court, such person shall not be excused on the basis of the privilege against self-incrimination. What year is this? This is 2022. Judge, this is not right. So, okay, let's keep going. This is a Georgia code that's against pleading the fifth. When pleading the fifth can be overruled in certain regards. So this is what this is talking about. Upon order of the court, such person shall not be excused on the basis of the privilege against self-incrimination, which is pleading the fifth, from testifying or producing any evidence required, but no testimony or other evidence required under the order, or any information directly or indirectly derived from such testimony or evidence shall be used against that person in any proceeding or prosecution for a criminal or offense concerning which he or she testified or produced evidence under the court order. So, okay, so Georgia is saying, if you want to plead the fifth, prosecution can say, well, based upon 25507's code, Your Honor, we want you to put an order requiring this person to testify, and whatever said in this testimony, he cannot be prosecuted for based upon this particular information here, where it says that any information directly or indirectly derived from such testimony or evidence shall be used against the person in any proceeding. Wait. But no testimony, I'm sorry, it starts at this part. But no testimony or other evidence required under the order or any information direct or indirect derived from the testimony or evidence shall be used against the person. So no testimony is where that is. So his coverage, his Fifth Amendment coverage is still there. So they won't prosecute you for the testimony that's required for that particular order. But just because you plead the fifth, Georgia says we still can put an order for you to testify, even if you're trying to insert the pleading the fifth privilege. But it still gives you some kind of coverage just because it says that the testimony and the evidence that you give because of that order, they cannot turn around and prosecute you on that. That's what that long sentence says right there. However, such person may nevertheless be prosecuted or subjected to penalty or for forfeiture of any perjury, false swearing, or contempt committed in testifying or failing to testify, or in producing or failing to produce evidence in accordance with the order, but shall not be required to produce evidence that can be used in any other court of this state. Oh, good grief, what a double talking. So doggone confusing, right? Like, what layman is looking at this going, oh yeah, that makes sense. I have the right to the fifth, but I don't have the right to the fifth. And when I get the fifth, I gotta. So such person may nevertheless be prosecuted or subjected to a penalty or a forfeiture of any perjury, false swearing, or held in contempt in testifying or failing to testify, or to produce or failing to produce evidence in accordance with the order, but shall not be required to produce evidence that can be used in any other court of this state. So that's where the double talk comes here. Like, where's the case law? Someone has to make this plainer, because in one regard it says you can plead the fifth, but if you plead the fifth, we're going to put an order that makes you testify. However, you're only testifying, the information that you testify to is only pertinent to the order, and the order is only pertinent to this case. However, we can't use your testimony and the evidence that you present in this case to then turn around and bring another case and bring it against you. you still have coverage relative to the 5th, but you still have to testify within this particular case. Then it comes back to a sentence that says, but shall not be required to produce evidence that could in fact be used in a different case. Well, then I would argue, if as Attorney Bumpus or, Copeland's attorney, I would start arguing, we have a definite problem, because we have several cases. You guys are talking about several different defendants and several different trials where, and by Copeland's testimony, may have an effect on a different case, whether he is individually, going to be called upon or not, and that he needs to have the privilege to save himself, against self-incrimination. It may be, in fact, that the information and testimony that he gives is used in another case, whereas this statement says it shall not be required to produce the evidence to be used that shall be entered, but shall not be required to produce evidence that can be used in any other court of this state, which is Georgia. And you get several cases in Georgia. So if he's not required to produce evidence that could be used in a different court, and you already have several different trials going on relative to this RICO charge, why would he be ordered to testify just based upon that one little paragraph there? I mean, not the one little clause right there, sentence. Any order entered under this code section shall be entered of record in the minutes of the court so as to afford a permanent record thereof, and any testimony given by a person pursuant to such order shall be transcribed and filed for permanent record in the office of the clerk of the court. Okay, when did that happen, Your Honor? I don't think that ever happened. And I think this is where he gets into, well, you say I put in an order, so I put in an order. No, you're supposed to file it with the clerk. What order? What order did you put in? What did you order? You ordered the ex parte. I'm back to that. You ordered the ex parte hearing. You ordered him to testify. What was your order? And if you didn't put an order pursuant to this particular section, then he doesn't have an order forcing him to testify. And his Fifth Amendment right should still be upheld if you did, in fact, order against it. If a person refuses to testify after being granted immunity from prosecution, and this is the one that the prosecution probably cares the most about, and after being ordered to testify as set forth in the code, well, did the judge order him to testify? Did the judge literally say, Copeland, you must testify. This is the order of the court. I'm entering in the order pursuant to code section 24-5-507 that you must testify in this case. And if so, did he record the order in the office of the clerk? And if so, was that done June 10th at 9:07 a.m. when they first started this conversation? Because if not, then how does this code apply? I don't know. Where's this order at that said that he had to testify based on this code? Because otherwise, this section does not have application. If a person refuses to testify after being granted immunity from prosecution and after being ordered to testify as set forth in this code section, such person may be adjudged in contempt and committed to the county jail until such time as such person purges himself or herself of contempt by testifying as ordered without regard to the expiration of the grand jury. If the grand jury before which such person was ordered to testify has been dissolved, such person may purge himself by testifying before the court. Okay, so that's if there is a grand jury, then you do that there. If not, then you do it in the court. Now, the only thing I can think of is maybe the order was done when Copeland pled the fifth on the stand. We'll have to look and see. Maybe that's when the order was done, but I don't know if it was recorded. Okay, so back to ex parte. This is ADA Love talking to the judge. That's why they want the ex parte in the first place. We kind of went off and found out what the statute was talking about. Mr. Melnick relayed to Ms. Hilton on Friday that he had never heard of the statute 24-5-507. And on Friday, he sent an email. I don't know. So this email is probably the email that Steele was talking about with FUs going back and forth. I don't know if he intentionally copied Mr. Steele or Mr. Shard. I don't know if he unintentionally put my name on it. But he sent an email to Mr. Steele and Mr. Shard with me and Simone, copied, where he said, "This is the communication that I received from Miss Love regarding Mr. Copeland." Sounds like he didn't, based on that, sound like his intent was to inform the rest of the defense as to what you guys were talking about. My response was, whose interests are you protecting? Yours or Mr. Steele's? Whose clients? Which client are you protecting? Whose client? Yours or Mr. Steele's and Mr. Shard's? He wrote back and said, you are going to get him killed. You are making him a target. F you is what he wrote in the email. So this is a part of what Mr. Steele is informed of, and that's a part of his very first set of assertions with the court. And the court was like, well, that was in an ex parte hearing. However, what was in the ex parte hearing was that there was a communication sent to Mr. Steele. So he would have direct knowledge of this email if, in fact, the email was sent to him. Now, maybe it wasn't because he didn't seem to know it, but I mean, under these particular circumstances, under these set of facts asserted to the court in ex parte, Mr. Steele was the person that was being contacted. All right. And Mr. Molnick, he don't care. Now, the FUs of life, are they proper? No. Is it nice? No. Is it common? Yeah. I'm not moved. So the shock and horror, it's kind of like, have you they probably don't put it in emails though. Attorneys probably don't put it in emails as much, but the conversations on the phone, some attorneys fight like cats and dogs on the opposite side, and some of them are like besties. It just depends on what's being said. All right. So given that his concern is that by testifying, at least the one that he conveyed to me in writing, it's not, his concern has nothing to do with the exposure from the state. And if his concern, okay, so here we go. Here goes a little bit. So Miss Bumpus, now remind you, she was the stand-in attorney. She may not have known about this particular email, but Miss Bumpus says there was no threat. We don't know of a threat. Now, if this is what happened in ex parte in the hearing, ADA Love asserts that there's an email where the other attorney for Copeland, Melnick, asserts something to the effect that making him testify or whatever it is you're doing, he wrote saying, you are going to get him killed. You're making him a target. So F you. But Melnick puts that out. So that is probably why the judge was like, in the event of a threat. So maybe now Judge Glanville might have some defense to his actions for taking on an ex parte hearing. Look what details will do. Details can be a good thing. Details can change a mind easily, can they not? One of the defenses to having an ex parte hearing as a judge oversighting the case of a witness that's sworn in, or a witness, period. It doesn't say sworn in, it just says witness, is the fact that it's an emergency. And a part of it being an emergency is there's a threat upon life. So if Melnick, in fact, did send such an email stating that you are making this man a target by having him testify, you are going to get him killed, then there is some element to threat to life, if there is some concern for his well-being. So then that would give justification for Glanville having the ex parte hearing. Ooh, got to prove if that's true or not. Got to find out about that. So anyway, or at least he reasonably thinks it's true because this is what's being reported to him by ADA Love. So given that his concern is that by testifying, at least the one that he conveyed to me in writing, it's not, his concern has nothing to do with exposure from the state. His concern has nothing to do with exposure from self-incrimination is what she's saying. His concern based upon this email is the threat upon his life. So the court says his being whose concern? So she's now going to clarify. Mr. Melnick, if the interest that he is protecting is Mr. Copeland's freedom, he did not convey it by asking us what exposure does he face in testifying. He, in fact, if he's concerned that testifying will get Mr. Copeland killed, and he is not communicating with us. He's communicating with counsel of defendants. It would seem that he knows a thing or something that we don't know. Additionally, and I will let Ms. Bumpus tell you, he has said if Mr. Copeland testifies, he's no longer representing Mr. Copeland, which is strange because if your interest is your client, then it would seem you would want to be there for him while he is testifying. The court, well, he is on vacation this week. Miss Love, I understand. That is why he has Miss Bumpus here, and he has said what he has said, okay? whatever that is. And as I was reading the statute, the thing that is, and I was reading the statute about this particular situation, and I was reading our rules, our ethic rules, rules of conduct for attorneys. And it is clear that if an attorney, there were two things that were happening. And it is clear that if an attorney, there's, okay, this is what I say, black and white should make it sound silly, don't it? One, Mr. Melnick had told me that he wasn't Mr. Copeland's attorney or a lawyer. Actually, no, he said, okay, whatever. This is what she's saying. These are her facts. Mr. Copeland told Ms. Hilton that Mr. Melnick wasn't representing him. Okay, so the client has informed the same. And then rather than Mr. Copeland reaching out to Mr. Melnick apparently was in communication with Mr. Steele and Mr. Shard. And Mr. Melnick reaches out to Mr. Copeland and injects himself in these proceedings. That's a whole lot of conjecture, but okay, I guess. What we are discussing was in no way a matter that Mr. Melnick was representing Mr. Copeland on, and that is where we are not allowed to speak with a person when they are represented by counsel. The way this speech is so hard to decipher in black and white. I know that Old English is disturbing to a lot of people, and it's hard. It can be hard, but it's easily to understand. When everyone speaks one language in one good direction, we can all understand. Well, what we are discussing was in no way a matter that Mr. Copeland was representing, Mr. Melnick was representing Mr. Copeland on. That's what we are not allowed to speak with a person when they are represented by counsel. What? There's definitely information missing here. The most I can glean from that statement is that Prosecution A Love believes that her conversation with Melnick was not to the attorney of Mr. Copeland because he had already stated that that's no longer his attorney. However, the privileges of attorney-client privilege and attorney work product privilege still are covered regardless if they are still employed by that client or not. So I don't know what she's trying to assert. It's confusing. Mr. Melnick could not have been representing Mr. Copeland on anything we were talking about because we were talking about this case and this trial. So, okay. So they're in an argument as to who the witness's attorney is. Okay. All that aside, yes, let's put it all the way aside because if he was his attorney at any point in time, he still has privilege. That client still has privilege unless the client waives it himself. All that aside, we would like an opportunity for the court to address Mr. Copeland and Mr. Copeland's stand-in counsel present, Ms. Bumpus, and looking at me like, oh, so much attitude with these attorneys. And I can just see Miss Love because she just be a rolling and just a body languaging it. So I can just tell, and it's, I'm making assumptions, but so what? I'm not in court. I can assume whatever I want to assume. But I can just tell Miss Love is just like attitude central because what she's saying is she's in mid-sentence to say, I would like the court to address Mr. Copeland and Mr. Copeland's stand-in counsel who's present. Then there's a cutoff where she's like, Miss Bumpus is looking at me like, okay, yeah, I'm gonna look at you like, what you talking about? And Miss Bumpus interjects, I'm listening. Like, yeah, I'm looking at you and I'm listening to you. What you got to say? I can just see the attitude. I can hear it. Miss Love goes back with his stand-in counsel present and to allow Miss Bumpus an opportunity to explain to Mr. Copeland everything that I have just said, which was, what did you just say? There's a missing piece. I mean, shout out to the court reporter. I'm assuming she is. I don't know. Something is missing. I don't know if it's missing because we need to go back to the hearing and see what was said there. I don't know, but something is missing because she really hasn't said anything, as far as I'm concerned. So I don't know why she wants Miss Bumpus to address what she said. What did you say? You want to know who Melnick represents? Call Melnick and ask him. I represent Copeland. I don't represent Melnick. So what? Her concern outside was what is the largest he can stay in jail. What I relayed to her is the statute says until he purges. The court, now here's a problem. Here's a problem for me. The court's presence in this conversation is giving a lot of agreement to the prosecution, as if the court agrees to the prosecution's point of view, their interpretation of the law, agrees to the prosecution's abilities, and it gives more weight to what the prosecution is saying. And whether that's the court's intent or not, it's just your presence in and of itself is a problem. And then you turn around and finish her sentence, where she says, what I relayed to Ms. Bumpus is the statute says until Copeland purges, and then the court jumps in and says, by testifying, Ms. Love, his contempt by testifying. So this is very like, yep, we agree with one another, Your Honor. We read just fine. Yes, you and I both read just fine. As a witness, this is like he on their side. Like that's the come out. You're gonna come out and say he's on their side. The court, yeah, 507 is a little bit different. So I mean, Ms. Bumpus, so until the end of this is a question. So she does exclaim that one was in her interview that Copeland is the one who inserted that there was some type of 2-year penalty for non-testifying, or not being in contempt for 2 years for not testifying. And that's not, that came from him. That was no, so his concern was, how long am I going to be here? And 88 Love and everybody else is like, 2 years? No, not 2 years. It's for as long as this thing lasts. So here we have Ms. Bumpus on the record saying, so until the end of this. Well, what is this? I don't know. The end of these 6, until the end of this trial, or until the end of the 28. Because remember, there's 28 indicted defendants. We're in one trial right now. Another set of defendants are getting ready to go to trial. Some of them did not accept their plea deal. Some of the others have an extension of time because they haven't been able to meet with their attorney to even discuss what the plea deal may or may not be. All right, so the court says he can be here until the end of the trial. That is what I said. So Ms. Bumpus, that's what I said. So the end of the trial is the longest question. Ms. Love, no, it's not the longest. Even after a grand jury, if a person has been subpoenaed to testify before the grand jury, and even after the grand jury has what it is convened, oh goodness, what's she talking about? Has left. Okay, so even after the grand jury has left, that person can still, until that person purges himself of contempt by testifying. The statute literally says that. Okay, so she's going back to the statute we just read. I don't know that the judge even asserted that statute applied, because he said it was a little different. Okay, let's keep going. See if we get somewhere clear with this doggone transcript. Well, so Ms. Bumpus again, well, I'm going to look it up, because it was my understanding that it was until the end of the trial, that he would be held in contempt until the end of the trial, not some indefinite amount of time. And Ms. Love is like, nope, here it is, literally the words of the statute. And so the court interrupts, and he could be in there a while. Let's put it that way. Either way, Ms. Bumpus, I just want to be able to give him court. I know. It's kind of the statute says. See, that's the thing with this judge. The record is never clear, because he just interrupts. Everybody just interrupts everybody. I know. It's kind of the statute says, that you purge, but I can't keep him in there indefinitely. I can't keep him in there indefinitely. I've got to kind of, Ms. Bumpus, right. That is all I want to know. The court, the whole thing is that he can. He has the keys to his own freedom. And that freedom is, if he just gives his testimony, then he's purged it. So he won't be in contempt. If he testifies, he won't be held in contempt. He won't have to go to jail. Okay, right. The judge says, I cannot keep him indefinitely. But 88 Love, and whatever that testimony is, we know what we believe it to be, but we don't know what it is. We can't talk about it. We don't, we don't know what he's going to say. We have an idea. We know what he's told us. Okay, yeah, Ms. Bumpus, Ms. Love. And our concern is that our concern, I know the court said essentially you, what is this? Intimidated that, what is this word? Intimated that Mr. Melnick probably told him essentially you should testify. What? What is this? What would make you think Mr. Melnick said he should testify? That they are not going to, they can't do anything with your testimony? But what we overheard being said was they are going to hammer you, as if we're going to expose Kenneth Copeland to. That's probably this. Miss Bumper says, you heard that? Miss Love, yes, yeah. Mr. Melnick told Mr. Copeland we're going to hammer him. The court, now to be fair, and I think Ms. Bumpus, as an advocate or anybody, has got to tell him he's going to face some pretty significant cross-examination. Okay, yeah, I think that's what he meant. Ms. Bumpus says, the court, I mean, he's got about 10, Ms. Love. So he meant the defense is going to hammer him? As a question, Ms. Bumpus. No, just in general. It's not going to be a, hey, da, 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 da. Words matter. I don't know what y'all saying right here. Ms. Love, he knew that. He already been expressing that. He had already been expressing that before. But I mean, I think that if he's concerned about that, well, but it's all in the message and the packaging in terms of, I think Mr. Copeland is, a savvy person. But, he's certainly going to be subject to a thorough and sifting cross-examination. So I don't think, hold on, let me see something. Cold in my house. They have the air on. And I'm freezing. Okay, so anyway, I don't think Miss Love believes that. To her expression so far, I think she feels like Copeland, the witness, is being told that the prosecution is going to hammer him. But, you can understand it, get hammered one way or the other, whoever it is. It's very seldom that you're going to be the best witness for both sides, right? That's only the experts who are really good and don't get hammered. They just tell it like it is. It's like, okay, it's like it is. Okay, moving on. All right, so Ms. Love goes, and the other thing is that, Ms. Bumpus, can I just say something in Attorney Melnick's defense in response, just for the record? Ms. Love, yes. Actually, it would be the court who gives permission, but whatever. Ms. Love does it. Ms. Bumpus goes, the reason that he doesn't want to move forward with representation, what I have been told, if he decides to testify, is that he doesn't feel like he doesn't know what was said outside of his presence. So he doesn't feel like he can adequately represent him or counsel him because he doesn't know what was told to the state when he wasn't there. Interesting. So how did you guys talk to the, I guess when he talked to the detectives, outside of that, when the witness has an attorney, you're supposed to talk to the attorney. And you say, bring your witness in so we can testify. And it's done all in front of the attorney. So Ms. Bumpus is saying that Melnick doesn't want to represent Copeland because there's times that communication has been without him. Ms. Love rebuts it. But the thing is that the only thing that he should be concerned about is the criminal exposure or the exposure that Copeland has criminally. And there is nothing. There's literally nothing. The statute is quite clear that we can do to him about the only thing that would put him in harm's way is a lie and a refusal to testify after being ordered to do so by the court. Okay, so this is different. I'm not sure what the other person reported to Steele, but in Weinstein, but ADA Love is saying in this sentence, based on the statute for which we just read, that even though pleading the fifth is a Fifth Amendment right to a United States citizen within the state of Georgia, they have a statute that says you can still be ordered to testify. However, the information that you give, the evidence that you give, testimony and otherwise, in that particular order for that particular case, that information cannot be used against you. So you still have self-incrimination privilege of, not incriminating yourself, but you still have to give up the information. It doesn't prevent you from telling it. So that is what ADA Love is talking about here when she says the statute says he does not have criminal exposure. The only way he would be exposed is if he were to lie. That would put him under criminal exposure. And the other way he would be exposed is if he refused to testify. That would put him under criminal exposure, being ordered to do so. So if he's ordered to testify and he doesn't testify, then he would be criminally liable. That's what she's saying here. So we'll go through and see if there's any other place, but that whole thing about if he lies, we won't criminate him is not what was said. It was if he lies, that's when he will be criminally exposed. So I'm really going back to Copeland. Someone knowing Copeland is probably the original snitch. It's like the evidence so far is not aligning with the ex parte. So the evidence in the ex parte does not align with the affidavit of the motion to recuse so far. Well, we got a ways to go, so let's see. And by a lie, we don't mean like, oh, I think you're lying. It would have to be, something obvious, because we can always impeach. But if he literally perjures himself, that's something different. We can't help that. We can't control that. So if we have to impeach him, basically he made a different statement at one time versus this time, we will impeach him. But if he actually goes and perjures himself, lies under oath, then we can't help him. We can't control that. Then he would be considered exposed criminally. We would only say, tell the truth. I don't care how bad it is, just tell the truth. So, like he says, I didn't go down to the police station. So, okay. I guess she's giving the example. There are times when Copeland says he didn't go to the police station, but yet he's at the police station on camera. So you went there. Somehow you got there. So that was the lie. I think they only used it for impeachment purposes. They only impeached him. Well, I don't know, but this wasn't a previous statement. But anyway, that was a lie on the stand that he gave, and they knew he was a liar. I kid you not. Like he said, I lied to lie because I want to protect myself, and I think the lies protect me. So I don't remember my last lie because I'm trying to come up with my next lie. he's like, I lied to lie. That's what I do. So the court, and I think part of his challenge, Ms. Bumpus, may be that you need to assure him, look, I'm going to be here. And if you think that they are asking you a question, they being the state or the defense, is asking you a question that's going to bring out other crimes that he's going to be able to look at you and say, can I have a chance to talk with you? So the court is giving Ms. Bumpus instructions as to if he feels uncomfortable with being on the stand and he feels like this is going to open the door for another crime, he should speak to you as his attorney and just, stop the testimony and ask to speak with the attorney. Miss Love, that's exactly right, Miss Bumpus. Miss Love, see? But that's just it. Miss Bumpus, no, he's not. Miss Love, hold on. That's just it, Judge. The problem is that there's been an assertion that people are representing, and I'm not talking about you. Where is the rest of this? I don't know. There's how did we get here? What, I'm back to Weinstein. I mean, not Weinstein, Adams. Remember Adams was like, I don't want the prettied up version of the transcript. I want the rough. I want the hearing. I want the recording. I want the whole package. I'm with him because this part makes no sense. What are you talking about? Ms. Bumper says, Ms. Love, see, but that's just it. No, he's not. He's not. Who's not? What's not? Not what? How do we get to this part? And then Ms. Love, hold on. That's just it, Judge. The problem is that there's been an assertion that people are representing, and I'm not talking about you. Ms. Bumpus, yeah. Ms. Love, there's been an assertion that people are representing that their biggest concern is his best interest, and then they are just not here. And Ms. Bumpus is saying she's not in a position to do that. So something has this transcript, there's pieces missing. And I don't think this is the full transcript. Because that just makes that movement of conversation make no sense. There's a piece missing. No, I'm not saying I'm not in a position. I'm saying that the agreement between Mr. Copeland and Melnick, who I'm standing in, is that if he chooses to testify, I'm to get him to sign this paper that says that then discharges Melnick as his rep. That's their agreement. I can't do anything about that. Okay. Okay, so the missing piece of the transcript sounds like, based upon this next page, is that Ms. Bumpus represents that if Copeland is testifying, he doesn't have representation any further. And it's based upon, they have an agreement in place, him and Melnick. Melnick, Bumpus is only standing in for Melnick. So consequently, when Melnick is no longer employed, neither is she. This is what it sounds like to me. And that's what ADA Love was getting, up in arms about on the page before. They probably kept it out because it's probably attorney-client privilege or something. So maybe that's why they kept it out. But that jump around was at least put something in the transcript that says under seal or something. Don't tell me this is the whole transcript and then you have evidence that shows that there's pieces missing. Ms. Love, that sounds weird. That does not sound like something in Mr. Copeland's best interest. That sounds like protecting somebody else's best interest. If you talk, I'm not going to represent you. I don't even know what to do with that. Clearly. Ms. Bumpus says, well, he said he does not know what was said. Well, he said he does not know what was said. Okay. I guess Mr. Copeland doesn't remember what the agreement was. Ms. Love, it doesn't matter what was said. Ms. Bumpus, right. Ms. Love, it doesn't matter. And he didn't ask us. He didn't even inquire. Oh, okay. So when Ms. Bumpus says, well, he said he does not know what was said, Melnick's issue is that he doesn't know what was said to the state. He doesn't know what the other times of communication was. So he doesn't want to represent Copeland if Copeland's going to testify because he has no idea what he's going to testify to. And the whole purpose of him being in representation of the attorney is so that the attorney can say, oh, wait, don't start talking about that. Plead the fifth on this. This is how far you can go. They help you with realizing when you're going too far or you are getting ready to get yourself in trouble. But since he doesn't know what was said, he doesn't feel like he can properly represent him. And so Ms. Love goes, well, it doesn't matter what he said. And Ms. Mom's okay, right. And Ms. Love is, it doesn't matter. And he didn't ask us. He didn't ask the state. So he didn't even inquire as to what was said. What have you all talked about? He has been talking to Brian Steele and Max Shard. That's it. He is not talking to us. And in fact, when Mr. Copeland asked to speak with us, Mr. Melnick barges in and gets between Hilton and Copeland and literally keeps us from talking to him before he gets called to the stand. And that's troubling. Yeah, but is it troubling? I don't know, because maybe he is protecting his client. He wants to keep his client from talking to you guys when he doesn't have to and telling you too much, because one of the things Copeland has a problem with is talking. He talks too much and about stuff he doesn't, he says is a lie. But is it a lie? I don't know. He just says all these lies. We don't know which part of it's true. Ms. Bumpus. Well, I think what happened was, and I say this because I previously represented Mr. Copeland previously on his other stuff. So I know this is just what I think happened. I think how Attorney Melnick came involved was his representation of other, because he took my place. Copeland fired me and hired Melnick. And then this came about. And I think so at the beginning, Melnick was representing him. And then in his criminal matter that he had, but that's resolved, Ms. Bumpus. But when this case started, Melnick called me and told me that he was representing him as a witness at the beginning. I can assert that. Melnick Miss Love, Melnick has never in life, girl, please. This is 2 years ago, Miss Bumpus says. Miss Love, Melnick didn't, as a matter of fact, less than 2 years ago, when Copeland was sitting in jail for something else he had done, Melnick said, I don't represent him. He told me I don't represent him. And people were in the room. He was on speaker. He told me he didn't represent him. Now he ultimately did come about and represent him. But when we were trying to get it, I guess Miss Love, Copeland was like, he's not my lawyer. I don't have a lawyer. He's not my lawyer. And then, Ms. Bumpus, are you talking about recently? Ms. Love, so recently Copeland said that Melnick was not his lawyer. Ms. Bumpus, right. Ms. Love, when Copeland was in jail, Melnick told me he wasn't his lawyer. But our understanding was that Melnick was his lawyer for those criminal charges. And so the person that came in and argued, or at least stood in for him on his bond, and then on his subsequent plea, was Melnick. But I don't know whose interest he would be representing when he's not talking to us about what we've spoken to Copeland about. He could ask us, and we would tell him. So I don't know why he would withdraw his representation of him. If his interest is Kenneth Copeland, then why would you pull out the court? That doesn't make sense. Well, okay. It doesn't make sense, maybe, or it does maybe, because one thing is he's on vacation and you're making him testify during a time he's not going to be around. And he feels like he's communicated with the state during times that he wasn't around. And he's now come to the conclusion and found out in evidence, and this is one of the things you guys have got to learn. Attorneys do not like their clients to lie to them. That is because you put the attorney's bar license on the line when they start representing you and start defending you, and then it comes out it's all a lie. And it's like, well, wait, I didn't know this. They got to prove that they didn't know this, and this is what you told them. And so they were just going off of that. And it sounded reasonable. It was logical what you told them. They do not like when you lie, because that's why you have attorney-client privilege. They can't go run around saying what you told them. So be honest with them so they know what they're getting into, what angles to play, and what hand to play. Well, here's an attorney who feels like, he doesn't know what's going on with his particular client relative to the communications that he has had with the prosecution. The prosecution is like, that's fairy tale land. I don't think a defense attorney is going to say, hey, prosecution, tell me what my client told you, and just sit back and be like, okay, that's all they know. The prosecution is supposed to give over the whole file. This is true. This is what they do. But he's a witness, so I don't know how much information the prosecution is required to give that attorney. And I guess he doesn't trust him. I mean, so what? And the attorney doesn't have to represent Copeland. He doesn't have to. And Copeland doesn't have to have Melnick represent him. They don't have to work together. They can choose not to. So this is a lot of in the attorney's business, which is covered by attorney-client privilege, as to why he's not representing him. The basis of his assertion, the basis that he's informing everyone, is because he doesn't feel comfortable doing so due to the communications that have not been in his presence. Because even if the attorney finds out from the client what those communications were, there's the essence of this particular client has an ability not to be forthcoming. And I don't know if this is true with his attorneys or not, but when he's on the stand and when he's talking to the detectives, he is not forthcoming with information. He's hiding back, or not telling, or he's requiring someone to explain simple concepts and simple language to him. And whether he understands it or not, or if he's playing games, don't know. Or when he's with the detectives, he's very chummy, just trying to avoid being put in jail. He's telling them all kinds of things, truthful things, non-truthful things, whatever. So how is he as a client? Is he much of the same? And as an attorney, you don't have the right to disparage the client and say, oh, he's a liar, he lies about everything, and everything he tells me is a lie, and every time I turn around, he's lying to me. You can't do that. You can't disparage the client. So it may just be the safest thing to say is, I'm not fully comfortable representing him because I'm not sure of all of the information. That might be his easy get out of jail card. Maybe that's why the attorney is making that assertion. Don't know. That's all speculation. All right, Ms. Love, at this point, where he would face the most peril, if that is his concern. If his concern is, I don't know what they talked about, so I don't know what the court interrupts. And I thought that Ms. Hilton had a list of questions for Ms. Copeland anyway. Ms. Love, she did. The court, well, how come you all can't, Ms. Love? He didn't ask to see those. He didn't. And not only that, the court, well, can't you all share that with Ms. Bumpus? Ms. Love, well, Ms. Hilton has already shared it with Mr. Copeland, and we certainly will share it, generally speaking. What? Ms. Bumpus, can I read this email that Melnick sent me? I don't know if this will help you understand what he's saying. It says, "Hey, Kayla, I wasn't able to see Kenneth today. He went on Saturday and tried to talk to him before his flight. But I have talked to his family. So at first, Kenneth was going to testify, but has now decided to take the fifth. He may change his mind on Monday. If he does, then he's agreed to discharge me as his attorney. This isn't out of bad feelings, but I was not present when he met with the DA's office, so I can't really help him with his testimony. And then he gave me the discharge and told me that if he decides to testify, then he's to sign this." So I think there should be quotation marks after testimony up into, or it says, "Hey, Kayla." So it sounds like that's a quote of the email itself. And then Madam Bumpus is coming and saying, and then the attorney gave her the discharge and told her that if Copeland decides to testify, then Copeland is to sign that document to discharge Melnick. That's what that last sentence means. All right, so Ms. Love says, and that's just it. It's like you never know what somebody is going to ask. And if he's concerned about putting him in legal jeopardy, then it would seem like he would remain and allow Mr. Copeland access to counsel when Mr. Copeland is concerned that he's about to walk into an area that puts him in legal jeopardy. Okay, Ms. Bumpus, you can't switch how he gets called. You can't switch how he gets called, meaning can't you change his lineup? Can't you put him at a different time? Because the other thing is Melnick is not here. He's gone. And you told him that he needed to find someone to represent Copeland because he was testifying and that was it. And Melnick is like, well, I can't change my vacation. It's already set. And there's nothing nefarious about that. That is a part of calendaring. When you calendar a case with an attorney and you start talking about when depositions will be, when trial will start, the whole thing is when those attorneys are available. Well, guess what? This is 90 some odd days in, 100 days in, I think we're at, really. So consequently, this is probably the longest criminal trial in Georgia for sure. I don't know throughout any other state, but it's still a very long criminal trial. So, this attorney didn't know he was coming and he couldn't switch his plane tickets and his vacation package. And the judge said, it's too bad. So he found a stand-in. And Ms. Bumpus is questioning to Ms. Love, why can't you just switch when Copeland goes on the stand? And then Melnick can be here for it. Ms. Love, see, that's not in Mr. Copeland's best interest. That's in the defendant's best interest. When you say switch in how he gets called, what does that have to do with anything? Well, you want Melnick there so bad, then have it during a time when he's in town. That would be my response. Ms. Bumpus, I don't know. Maybe he's saying he can't do it because he can't get his refundable ticket. So they're back to the vacation part. Yeah, that's where I'm at. Ms. Love, that is not what he said in that email to you. And that is not what he relayed to the court. And his concerns have nothing to do with the court. He was very much, Ms. I tried to go back and watch as much as I could. I'll try to go back. That must be the first hearing. When he goes and pleads the fifth, that has to be the first hearing that they're talking about with Copeland testifying. The court telling me that he was going on vacation. And I said, well, you inserted yourself in this. I said, really, you need to come on Monday. How does the attorney insert himself in it if he's representing the client? So you give him a choice. Yeah. So you're telling him he's inserting himself into this. So you need to come. And he's like, I can't come. I got to go. So I'm going to send somebody. And matter of fact, take me off this case. Look, Melnick is the smartest one in the room. Take me off this case. Get me out of here. Miss Love. So he can't force Mr. Copeland to discharge him just because Mr. Copeland decides to testify. They came to an agreement. I think you are in until it's done. I mean, who, me? Miss Bumpus asked the court. The court, yeah, I mean, that's just, if he testifies, you've got to kind of, no, he's going without representation. I don't follow that line of logic. So the judge is like, well, if he's going to testify, then Miss Bumpus, you're going to have to be here in representation of this witness. because you're standing in for Melnick. But the problem is that's what she's doing. She's standing in for Melnick, and Melnick is discharging. He is not a part of any particular testimony. And when this is all over, I wonder if Melnick will ever tell. Did he feel like his client was being made to testify and doesn't want to testify? He pled the fifth, so what conversation are we having anyway? Because, yeah, I mean, that's just, if he testifies, you got to kind of, Miss Love. And frankly, Your Honor, I know that if a person faces criminal contempt, they are entitled to representation if they want it. This being a civil contempt matter, the court, not necessarily anybody who's facing contempt can get counsel. Anybody can have counsel. I mean, not anybody, but anybody can get counsel. This is America. You want an attorney, you can get an attorney, you can pay for it. It's we won't pay for all attorneys, but if you want an attorney for something, you can get one. The court, not necessarily. Anybody who's facing contempt can get counsel. I mean, not anybody, but Ms. Bumpus, I can't say how long is this going to take, Ms. Love. It might take some days. Ms. Love. And see, that's just it. And I think Ms. Bumpus is putting in a precarious. I think Ms. Bumpus is I think Ms. Bumpus is put in a precarious position. She's not the one that stood up and injected herself into this. They reached out to her and she did him a favor. But ultimately, it seems as if Mr. Melnick is stalling and attempting to delay and hamper and hinder our proceedings. And that is a problem because that has nothing to do with the best interests of Copeland. And that has nothing to do with Copeland's exposure if he testifies. Just to answer the question about what he is exposed to, the statute is very, very clear. It literally says that no testimony or any evidence required under the court's order or any information directly or indirectly derived from such testimony or evidence shall be used against the person in any proceeding or prosecution for a crime or offense concerning which he testified or produces evidence under the court order. That is saying even if he got on the stand and said, he started talking about an unrelated crime, which is what the biggest thing I think he's probably thinking about is that, there's a lot of stuff they could ask me about, Miss Love, right? The court. That is not known to a lot of people. And that, he could also invoke his Fifth Amendment with the advice of counsel if it was some other particular crime. But, Miss Love, even that, even that, he'll still have to testify, Miss Love, literally, right? The Salays, what is this? The Salays. That probably means to say the law says. I think the S and L are in the wrong place. The law says, but anyway, the court says, anything he testifies to, we do this, okay. And then about the delay or stall, isn't it true or is it not true that he had a leave filed since December? Ms. Love, we had nothing to do with any of that. He injected himself into this. The court, see, the problem is, Ms. Love, he stepped in the court that when you get involved, I don't know, you have a leave. Okay. All right. A leave since December. So he had he had stated to the courts, maybe in some other proceeding, I don't know why that would be part of this, but he should have told this proceeding he's not available during this time frame as the attorney because he has a vacation that he scheduled in December. So he's told all of his courts that he's presiding in, look, I have a leave this particular time, a vacation leave, a leave of absence, whatever. This Judge Glanville is like, I don't know that because he injected himself into this trial. He wasn't originally part of the trial, so he had nothing to do with the calendar as the attorney because he's an attorney for a witness. He's not an attorney for a defendant. All right. So, Love, of course, is right. The court, and unless you filed that leave into this case, you don't have a leave for my case. Okay, so that's what Glanville is saying. That makes sense. He doesn't. So that court would not know of his particular leave of absence request and his unavailability as an attorney because he's not an attorney originally part of the case, and he didn't file that leave in his case, so it's not on his docket. He has no knowledge of it as a court. So they are scheduling witnesses and presenting things in the calendar timing that they've agreed to, not knowing this particular attorney has a stake in the game. They have no idea he has a dog in the fight. It's Bumpus. Okay. Ms. Love, and he did not, the court. So he didn't have one. Ms. Love, Mr. Copeland's been a witness and a name on this witness list since the court. So since he said, well, I represent him, I'm like, okay, well, you don't have a lead. That's filed in our case. Ms. Bumpus, okay. Ms. Love, so he did this to himself, meaning the attorney Melnick, did this to himself, and he did it to you because he asked her to come and represent. But we have to, that is just where it is, and I don't know that that's just where we are, Ms. Bumpus. So, Judge, you are going to make me stay if he chooses to testify. The court, I am, because you're his lawyer. You're his lawyer. You're a stand-in lawyer at this point, Ms. Bumpus. Your Honor, I don't have a problem with that. I'm not ready. There you go. Problem. How do you expect her to have his best interest in mind, Copeland's best interest in mind, when she doesn't have any knowledge? She doesn't know what's going on. Oh, excuse me. The court. There's nothing for you to be ready about. Really? I mean, here's the thing. I think the only thing you got to kind of ask him about is, look, here is the questions the state is going to ask you. All right. Is there anything else that could hurt you that they might ask you about? And as long as you have knowledge of that, then I think that you are fine, because the state's only going to get into this. So he's talking about the list of questions that Attorney Love says Copeland has, but it's not confirmed that Melnick has them. I don't know, maybe Melnick has them, but consequently, Bumpus most likely doesn't have them. So the judge is like, look, take a look at these questions, ask him if he is familiarized with these questions. If he answers these questions, will he be opening himself into any other crime that's not relevant? Will he be hurting or harming himself anyway? Oh, so sorry. Now the reason you want to know what's going to hurt you is the defendants know more about Copeland than anybody else. So they are probably going to kind of, I don't know about that. I think that paragraph is a problem. I don't think there should be any, that's disparaging to the defendants. Defendants know more about you, so they know your true demons. They know your skeletons, if you will. So what they can do, we don't know what they'll do, but this is what the prosecution is going to do. This is their question. The defendants can only respond to what was brought out in prosecution. Now, if you open the door to something, then obviously they can explore that. But if you stick to the subjects and the questions that the prosecution has laid out that is for that particular set of facts that need to be asserted, then the defense can't just come in and start talking about what the weather's like. They can't just go off topic. They have to stay within bounds of the original set of questions. So what an interesting way to put it. But at this time, I guess Copeland's in the room just because of the way the judge read the timeline off. But it reads almost like it's attorney to judge, and the flow is continuous and everyone's cutting everyone off, and they're all trying to get a feel for it. But at the end of the day, the judge is siding with the prosecution. That's the feeling of this exchange. So Ms. Bumpus comes in. What about if I say I can't do it? Then Melnick needs to come back, right? Am I going to be in trouble because I was only, I think she says here, but I was only for Monday. That's what I was told. I was given a specific, she was given a specific instruction. And Ms. Love, if Copeland said, I don't know what Mr. Copeland wants, it's his choice. Ms. Bumpus, can't he say he doesn't want Melnick? Right. So that goes all the way back to the very beginning of the argument, where Copeland and Melnick come to an agreement that if Copeland testifies, Melnick is no longer his attorney. And Ms. Bumpus has inserted the fact that she was only there for Monday. She has to go back. Which I believe she's in Texas. So this is in Georgia. She's also licensed in Texas. And she's like, I got to go back to my regular practice. I'm only here as a stand-in. And Ms. Love asserts, well, it's up to Mr. Copeland if he wants you to stay or not. It's his choice. And so it's like, great. I'm glad you agree. It's his choice. And his choice is that he doesn't want Melnick, and I'm not here. So, it's like that double argument. Everyone loves the argument when it helps them out, but no one understands that it can flip on you and come against you all the same. Ms. Love's response says, he can say whatever he wants. It's his choice. Exactly. It is the client's choice to have representation or not. Ms. Bumpus, but the judges say, exactly. The judge just said, you're his attorney. You have to stay. And, so Love is coming in. Thank you, Chloe. Thank you, Chloe. So, excuse me, Chloe's popping in. So the judge just said you have to stay. But Ms. Love is like, no, it's up to the client. Of course it's up to the client. But the judge is also, the other thing about the judge, as much as we can scrutinize his activities in this case, any judge does not want a witness that has representation to all of a sudden be without representation, or a defendant just all of a sudden. It's preferable that you have representation so that the rights are being preserved, that they're informed about what they don't have to do. And it's better, I'm with him on that. It's better for him to have representation, but to force him to have representation is a whole nother thing. So, yeah, it's always going to be the client's choice. But if you ever see a defendant who's like, I want to go in pro per, they have to show competency enough to be in pro per. Like, you got to be able to articulate. And you don't need to know the law, but because it's your choice, you're supposed to know it. But if you know it, you know it. If you don't, you don't. Judges won't get mad about that. But if they feel like you don't have the mental capacity and competency, and a part of your plea might be mental health issues, you're going to be in their courtroom defending yourself. They're going to appoint you an attorney or guardianship, put you under some type of, get you some type of assistance to help speak on your behalf. Okay, so I don't think he can be forced to have representation if he doesn't want, need, or say he wants it, because we have done everything to clear him of judicial exposure. There is nothing he can say. He could lie. That puts him in, the court peril. So she's going back to her original argument that everything he does is fine as long as he doesn't lie. And so this may be one of the problems. One of the things that Brian Steele said was, what was informed to him is that there were a number of people in and out. Someone might have walked in during a time when ABA Love is saying he can't be forced to have representation if he doesn't want it. We're offering him everything. We're doing everything to clear him of judicial exposure. There's nothing he can say. He could lie. And they walk out after that. They don't hear the rest of that. Puts him in, the court peril. As Love repeats. But, he can't talk about a crime that he can't talk about a crime that we could then prosecute him for. So consequently, we can't prosecute him for a crime if he starts talking about it based upon that statute. We read it already. So it bears to say, when did the person hear what was being said? How much did they hear, their recollection thereof? And was it doing one of these off statements where the full sentence is really not played out? The court that is involving this or some other place, right? Miss Bumpus, I understand that, but Miss Love, and we can't use his testimony to go find evidence to prosecute him for the stuff he talks about. Basically, he is literally shielded in the immunity deal. Ms. Bumpus, I would have to agree with you that I don't think that's the concern. Isn't that what you said? Well, the court said that. Ms. Bumpus, no, I'm saying with Mr. Copeland that's not testifying. You said you don't think that his concern is criminal exposure, or you do think that is what he's worried about. So I just want clarity as to what Ms. Love is asserting. What's the issue? The court, do you think that he's fearful of testifying for other reasons, like for his personal safety? Ms. Bump is right. Ms. Love, that is what Mr. Melnick said to me in an email. I can pull it up. He said, Ms. Bumpus, but you don't believe that. Ms. Love, you are going to get him killed. That's what he said. We ain't gonna kill him. Ms. Bumpus, see, I don't know anything about that email. Miss Love, we ain't gonna kill him. I can show you the email, but we're not going to kill Kenneth Copeland. So who is he talking about? So what are you trying to do? The court. That is a collateral second and third order effect. You know, let's pray it doesn't happen. But Miss Love, I mean, obviously he first, the court interjects, he has to give testimony though. I mean, that's what he has to do. He's got to give the testimony, whatever it is, good, bad, or indifferent, good, bad, or indifferent, I would say. Miss Love, so we would like, with the court's permission, they haven't brought him over, and he was supposed to be the first one up. So I guess they went to get him. They might be over here with him now. Is he here now? I don't know. So he exits the chambers at 9:33. So this is a 20-minute, a 13-minute conversation. They started at 9:10, right? So this is a 13-minute, 23-minute, do math. A 23-minute conversation. Roughly. Between 13 and 23. I don't know if they started right at 10. Did they start right at 10 or they started at okay, you're on 21. Started at 9 a.m. or 9:10. Oh goodness. I want to know. This seems like a long combo, but it might have just been 13 minutes. Okay, so the hearing began at 9:10. So it's a 13-minute combo. So the judge leaves because basically they don't even know if Copeland has come from the jail. So the jail has to bring him over. Okay, and so that was 13 minutes. Why do I keep saying 13 minutes? 23 minutes. 23 minutes. Math is so simple. Okay, so that was 23 minutes that they had this conversation back and forth on the proposition of the immunity agreement. How much time would he get if he does not testify and he pleads the fifth? And the court and the prosecution rest on this particular code, Georgia's code that was implemented in 2022. It's section 24-5-507, which we went over, the grant of immunity and contempt. Whereas in the subsection B, if the person refuses to testify after being granted immunity from prosecution and after being ordered to testify as set forth in the code, such person may be adjudged in contempt. So the judge can put him in contempt if he refuses to testify. But what I don't know is if the judge actually did the official order for him to testify, because based upon this section, pleading the fifth is not a get out of jail. You still got to testify. So it doesn't prevent you from testifying based on that in Georgia. I don't know if other places have it, but Georgia has it. Okay. So he leaves. Glanville is gone for about a minute. During such time, Ms. Love says, we would like to just go into another courtroom and talk to him, give you a chance to talk to him, and then give you an opportunity to explain to him, the court reporter, we're off the record. Brief recess. Judge Glanville comes back into chambers at 9:34. So what was said when you were off the record? They went off the record, but then for a few moments, a minute later, they're back on the record. Miss Love, Miss Hilton has been communicating with him. I'd like to grab her from downstairs and have her come up. Or where is Mr. Copeland? Mr. Chamberlain, they took him upstairs to the tank in 9. Okay, so he is in the courthouse at 9:30 something. The court, okay, can we bring him out to, Mr. Chairman, your chambers is being used. I mean, your courtroom is being used. Okay, so the courtroom, they've opened it up to the defendants, is what this means. The defendants are in there. The court, let's bring him in here. So they will go and make the decision to bring Mr. Copeland into chambers at this time. This is after the preliminary conversation with Ms. Bumpus. Mr. Chamberlain, all right, so let me see if I can get him, or get that done. Let's the court bring him in here. Okay, thank you. We'll just bring him in here. So they stood in recess from 9:34 to 10:03. type of recess was that? Why are we off record? Are we really not talking between 9:34 and 10:03 for 30 minutes? What is this the time she went and was talking to Brian Steele? I don't think so. I don't think so. But anyway, so they're in recess for 30 minutes. Mr. Copeland enters the chambers at 10:03. Also present is Judge Glanville, Assistant District Attorney Simone Hilton, and Attorney Kayla Bumpus, Court Reporter Christina Weaver, Investigators Antonio Long and Rashid Hamilton, and Deputy Houston, Deputy McPherson, Sergeant Brown, and Sergeant Hall with the Fullerton County Sheriff's Department. This is like worse. So in the beginning, when I thought Copeland might have been around, it was just up until the investigators and Long and Hamilton were in the room. But now we have the prosecutor, his defense attorney, the court reporter, the judge, investigators, 2 of those, deputies, 1, 2 of those, and 2 sergeants. So we have 6 official looking personnel, and the court reporter, the judge, Kayla Hilton. That's 10 people in this room. I hope this is a big chambers. Okay, the court says, Mr. Copeland, can you let me know I got a hearing problem? Oh, can you let him know I got a hearing problem? Okay. So Mr. Copeland informs the court. I wonder where they were getting that from, but he does. He officially informs the court that he has a problem with hearing. Ms. Bumpus, okay, he said he is hard of hearing. The court, that makes 2 of us. I've got a hearing aid that's coming on the 27th of June. So I'll try and talk loud. Is it okay if Mr. Copeland, yeah, I can read lips. The court, okay, good. Mr. Copeland, good morning. Good morning. The court comes back. All right, I just wanted to bring you over and let you talk to Ms. Bumpus and see if there's anything that you need to ask of your counsel or Ms. Hilton or the state or the court before we bring you out this morning, because we would like to hear your testimony, and that is kind of where we are at this point in time. So is there anything you want to ask? Well, I don't know. I think Melnick's email, whether properly asserted or not, whether we're interpreting it correctly or not, is what gives the judge and everybody the supposed right to have an ex parte under these emergency circumstances, because he is stated you're going to get him killed. That's an alarming concern. There's some type of threat to this man's life if he testifies. That is what his attorney asserted in an email, supposedly based upon what ADA Love read. And if it's an email, then that's easily provable, right? You can just go ahead and give it to the court. So with that being the case, the ex parte becomes a proper hearing. That, yeah. So may not happen. Much may not happen off of this ex parte hearing. We're going to find out what the legal scholars say about it, but so far, that alone gives the judge enough reason to need to have an ex parte hearing so that the witness can state his concern for life or threat thereof, whatever. So Mr. Copeland says, well, I want to speak to you personally that I have never been truthful a day in my life until I just made this statement right now. First question. If you thought it was hyperbole, if you thought I was making it up, whatever. If you ever had a question about Copeland being able to tell the truth, and it just brings you all the way back to why would any attorney want to rest their case upon someone who's a liar, who is telling you, I am a liar, I'm nothing but a liar, all I do is lie, I've never told the truth. And this is Mr. Copeland. First words out his mouth as far as testimonial concerns, I want to speak to you personally that I have never been truthful a day in my life until I just made this statement right now. That may be very important for the defense to know that this witness is confessing to being a habitual life. I don't comprehend none of this stuff that's going on. Doesn't understand it. Okay. About that. The court, okay, well, the only thing you can give is truthful testimony. I mean, whatever you know is whatever you know. I mean, that's it. So the court does assert that you have to give, your testimony has to be truthful. I guess the only concern is that he says the only thing you can give. I mean, he could just like Brian Steele, he could, go ahead and be held in contempt. He could be okay with that. Because he doesn't have the ability to tell the truth. Right, so Ms. Hilton, and what we'll say, and Mr. Copeland and I, we have talked about this. I'm not sure what your concerns are, what concerns that you expressed to Mr. Melnick last week. But if any of your concerns deal with being locked up for anything, you can't. Like, there's nothing that can happen. The feds, Ms. Bumpus, well, that's not Ms. Hilton. It is true. Oh boy. Ms. Bumpus, no, I said that's not his concern. Ms. Hilton, if his concern is safety, we need to know that. Like, that's not expressed. So we don't know what the concern is, so that we can try to resolve the concern. Yeah, but I'm concerned with your statement that if your concerns deal with being locked up for anything, okay, not gonna happen. But back to Ms. Hilton. This is what I'm saying. Mr. Copeland and I have had conversations before. I understand some of his concerns is potential criminal liability, hence why we gave him immunity. The federal statute of limitations, done. This state statute of limitations, done. So there is nothing like, I researched it this weekend again. Both those statutes of limitations for what you and I talked about, which was in 2015 or before, done. You can't be prosecuted for anything you testify federally or statewide. Immune, period. So if that is the concern, there is none, because you cannot be prosecuted. The federal statute of limitations is 5 years. So anything in 2015, 5 years would have been 2020. Anything statewide for 4 years, it would have been 2019, finished. So she's just affirming that. So what does he need an immunity deal for if he can't be prosecuted in the first place? She's affirming that the statute of limitations have ran out on the things that he did in 2015 based upon things that were state concerns. That was a 4-year statute of limitations, and things that were a federal concern, that was 5 years statute of limitations. So both of those limitations have well passed, because that was 2019 and 2020 respectively. 1 second. So I'm trying to express to you, we do not want you locked up. I don't know how many times I've got to tell that to you. What I've got to say to you, we do not want you sitting in DeKalb or wherever. They got you because of this. I know you wanted to talk to me on Friday before you walked into court. We weren't able to talk. If you still want to talk with or without Ms. Bumpus, I'm here. But we do not want you in custody. You will not, this order, I don't know if you kept your copy of the order, but this order says you are immune from prosecution. Any of it, literally, judge, you might want to close your ears. If you confess to a murder on the stand, if we don't have any other independent evidence outside of what you say on the stand, you are immune from prosecution from what you say in the court. So prosecution is saying, ADA Hilton is telling him you have full immunity, and a part of that includes if you confess to a murder that we don't know anything about or have any evidence about, there's nothing we can do about it. So again, I don't know what was communicated to you on Friday. I have no idea, but what the state has assured you, which I have assured you in our private conversations with Mr. Long, as I'm saying in front of Ms. Bumpus, as I told you, that is what this order says. The court, and that is direct or cross-examination, Ms. Hilton, and that is direct or cross-examination, meaning that whatever he says on direct or cross-examination is covered by the immunity deal. But I don't know why the court is inserting himself into that explanation, but okay. So the court, if you are worried about what the defendants may ask you because they may know your business, but if they ask you about things that you might think you might have some liability with, you can't be prosecuted for any of those. So they're going back to, if defendants try to put your business out there on the street, don't worry about it because we got you covered with this immunity deal. Mr. Copeland, I have family members watching this trial, and I don't want my nephew and them to hear the things that I have been involved in and think it's okay. Ms. Hilton, but I think that's a separate conversation you can have with them as an honest individual. Like, look, nephews, I've lived the life that I don't want you to live. Don't go through what I've been through. But that's something you can have outside of being in jail, because that's a better conversation you can have with your nephews in person. So basically, don't try to have this conversation behind bars because you don't want to testify. Be out, be free and tell them don't live that life. Let me tell you. But they shouldn't have to come to the DeKalb County Jail because you are being held in contempt. You can have that conversation with your nephews tomorrow in person. You can have that conversation with them. You can have that conversation with anybody. What's coming up this weekend? Why are we in jail? What are we doing? Mr. Copeland, but y'all did this intentionally. No, we didn't. We did not. You and I had this conversation, Mr. Copeland, on Friday morning. So he got immunity Friday morning, I guess. Mr. Copeland, you knew my child's birthday was next week. Huh? Oh, okay. So I guess he believes like you put him in this precarious position where if he pleads the fifth, he goes to jail, so he's going to miss the birthday. So that's extra pressure on him to not plead the fifth. Okay, I don't know if that's conspiratorial on the prosecution side. I don't know if they're really that thinking about that, but okay. But what did I tell you when we met with each other? I said to you, you asked me, what is the one thing that's going to get me in jail? Didn't you ask me that? And what was my response? If you plead the fifth, and that is exactly what you did on the stand. Oh, that's the number one problem. That's a problem. Because pleading the fifth is not just the one thing, it's lying on the stand. So she said to him, if he pled the fifth, that's the one thing he can do to get himself put in jail. And he went ahead and did it. Okay, so Mr. Copeland, but what did I tell you before I got to that point? I told you the whole time, Tuesday, Wednesday, Thursday, Miss Hilton, but I told you we were giving you immunity, Mr. Copeland, that I was pleading the fifth. So he told you Tuesday, Wednesday, and Thursday, I'm pleading the fifth. And she said, but I told you we're giving you immunity. Miss Hilton, no, you did not. You did not. She said, so she's saying you didn't tell me that you were pleading the fifth. And Mr. Copeland said, I told you every day I was pleading the fifth. Miss Hilton, no, you did not. And I told you my concern, Mr. Copeland says. Miss Hilton says, and we said we could give you immunity. You said your concern is what they know about. And when you said that, I said, well, you know stuff about them. And then I said, whatever your concerns are, we can give you immunity. Mr. Copeland says, so I didn't tell you I lied on them to get myself out of the situation? Mrs. Hilton, you said you were a liar. That's what you said. You said you were a liar. Miss Bumpus, was this recorded? Miss Hilton, no. Miss Bumpus, and did he ever say that Melnick was his attorney? Miss Hilton, no. This week when we first met you in the car on Friday, we asked you, is Mr. Melnick your attorney? You said, he's not my attorney. I haven't even talked to him. Mr. Copeland, no, I never said he's not my attorney. I said I haven't talked to him. There we go. OMG, 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 OMG. Page 28, 27, I think is when it starts. This is when it hits the fan. This is when problems arise immensely. First, we're in ex parte with a sworn-in witness. And so the quote-unquote emergency was he didn't feel safe. Mr. Copeland finally comes to the conversation and says, no, it's not a matter of feeling safe. It's a matter of, I want to plead the fifth. And I've been telling you this Tuesday, Wednesday, and Thursday. And I pled the fifth on Friday. I told you I was going to. And she's like, and the one thing I told you that would get you locked up is pleading the fifth. That's the only thing you can't do. He's like, but I told you I was a liar. I lie about everything. And she said, yeah, you told me you were a liar. So you knew he was a liar, but the only issue you had with him was pleading the fifth. So far, that interpretation is correct. What is not correct is that the judge condones him lying, because in fact, earlier the judge says he can't lie on the stand. And based on the statute, he can't plead the fifth either. Pleading the fifth won't help him, but he still will have protection. So we got to explain that to him, that he still will have protection. So whereas every layman says, I plead the fifth to protect myself from self-incrimination, Georgia says you cannot plead the fifth. You still have to tell about the truth as long as you have an order to testify, and you will still be protected as if you had pled the fifth, as long as you have an order that protects you. And so the order that they have is the immunity. I mean, I guess that's this protects him. Oh, wait, but there's nothing like this point where he says, when Ms. Hilton confirms that Copeland said, Copeland, you told her he was a liar. That's what you said. You said you were a liar. Nothing like that piece of information. And Ms. Bumpus says, was this recorded? And Ms. Hilton, no. So you met with him, a witness. And so Ms. Bumpus, wait, did he ever tell you that Melnick was his attorney? Very good job on Ms. Bumpus's part, because Ms. Hilton's like, no, he said he's not his attorney. And Copeland's like, no, that's not what I said. I said I haven't talked to him. I didn't say he wasn't my attorney. I just said I have not talked to him. So you asked him if Ms. Melnick was his attorney. You didn't record the conversation. Why would you not get him to say something in writing, or at least definitely recording him saying, no, Melnick is not my attorney, when you're talking to someone that you have a reason to believe has an attorney, has counsel, and then this is Hilton, so that's different than the lady before. That was ADA Love, who was worried why Mr. Melnick looked so suspicious that he would want to be pulled out of the case. I mean, because you're talking to him without him being present. He's saying that he told you that that's his attorney, but he hasn't talked to them, and whatever. There's all this confusion as to if he represents or doesn't represent him. So he's like, look, I don't want to be in this. Let me out. Like I said, he was the smartest man in this trial. Smartest person was Melnick. Okay, because there's confusion as to if he even is the attorney. Ms. Hilton, you said he's not your attorney. You haven't talked to him. Then we continue to have a conversation. At no point did you ever say to us, hey, I want Mr. Melnick here. Hey, put Mr. Melnick on the phone. Mr. Copeland, you didn't make me feel like I needed him. Oh my God. I mean, we got to get the Dum Dum Awards around this part. Because the man says, I'm a liar. I lie about everything. He done told the judge, I lie about everything underneath the sun, anything and everything, all things. I lie about it. I am a liar. I lie. She knew before putting him on the stand. He said, I'm a liar. I'm gonna lie to you. I'm a liar. This is what you tell. She confirms this is what you told me. So you're talking to someone who's a liar, which you probably presume all the people you talk to is a liar at some point. But you know he's a liar, and you're not recording his conversation. Now he's coming back against you and saying you had a conversation with him without his attorney present, and he didn't know he had to tell you he needed him because you made it seem like he wasn't necessary. And he told you he hadn't talked to him, but he didn't tell you he wasn't his attorney. Sometimes you got to record conversations just for your own self. It don't even mean it, just for your own self, okay? All right, attorneys, ADAs, have good record keeping skills, because this right here is ridiculous. And he's a liar, so you should know he's going to lie against you. Why? What makes you think he's going to tell you the truth? He's going to lie to everybody else. Silly. Okay, Ms. Hilton. But if you needed him, we would have said, if you would have needed Mr. Melnick, we would have said to you, okay, just call him. So, I mean, that is our position. We don't want you in jail. We just want you to be able to purge yourself by testifying. Whatever your truth is what your truth is. But you've just got to answer the questions. Believe that whatever your truth is what your truth is. We know what you said before. I don't know what you're going to say on the stand, but what we know is pleading the fifth is going to keep you in custody. That's what I know. Now, how you answer your questions is how you answer your questions. I don't know what you said before, and I know what you said later. I know what you said before. I don't know what you are going to say on the stand, because you and I never went into full details about it. But what I don't want is you to be sitting here in custody. Mr. Copeland, you did it. Mr. Copeland, you did it. Miss Hilton, I did not do it. You did it by pleading the fifth. Oh, okay. You're saying you put him in custody? So you did it by pleading the fifth. Mr. Copeland, you told me before you went to the judge with whatever the thing called you went to him with, you told me that I can't, when I'm asked a question, I can say, I don't recall or I don't know. You told me that if I plead the fifth, I mean, something, why would I plead the fifth to something I ain't do? And I said that you don't know what I did and what I ain't do. And then you was like something. And then y'all asked for this immunity. And I was like, it was something. And then Thursday or Friday came. And then y'all go tell me, oh, we went to the judge with this. So you got to testify. If you don't testify, the judge is going to lock you up. It's Hilton, right? But that was based upon what you, Mr. Copeland, but I told y'all that. Ms. Hilton, no, you didn't. Mr. Copeland, you said, why would I plead the fifth to something I didn't do? And I said, you don't know what happened. Ms. Hilton, and I said, I don't know what happened. Only you know and them know. I said, but you never said I am pleading the fifth. You said, what if I do this? What if I do this? What if I do this? Mr. Copeland, I told you. I said I'm going to plead the. You said, why would you plead the fifth? To something you didn't, that you know you didn't do, Ms. Bumpin. So if you didn't have immunity prior to this, that what you're saying, that you feel like he didn't have immunity prior to, Mr. Copeland, immunity came Friday, right when I went to jail. Ms. Hilton, the immunity only came after Mr. Melnick. Ms. Bumpus, hold on. Ms. Hilton, the immunity came after Mr. Melnick sent us an email saying, my client is pleading the fifth. That was on Thursday evening at 6 p.m. Okay, Ms. Bumpus, Ms. Hilton. So after that, that was an empathetic. He is pleading the fifth. Right. He said it. He said my client is pleading the fifth. Ms. Bumpus, Ms. Hilton, we came and we got this signed. Ms. Hilton. And then Friday morning came. Okay, Ms. Hilton. So between Friday evening, Mr. Melnick reached out to us, said he represents him. That's Thursday evening, actually. Said he's pleading the fifth. Ms. Bumpus, okay, so and when was the last time you talked to him before Melnick got involved? Ms. Hilton, we talked to him earlier that day on Thursday. So you talked to him on Thursday, and he said, you asked him, was Melnick his attorney? And he said, I haven't talked to him or whatever. He said he wanted to plead the fifth. You said, why would you plead the fifth to something you didn't do? Whatever. He tells Melnick. Melnick sends you an email and says, my client is pleading the fifth. So he told you straight up. So why are we here? So he gave him an immunity deal so that he couldn't plead the fifth. No, he went up on Friday. He went to testify Friday morning. He pled the fifth. Then you gave him the immunity deal. What? I'm back to Bumpus. When did the immunity deal get signed? Copeland. Immunity came Friday, right when I went to jail. He went to jail for contempt. So he pled the fifth. They sent him to jail. That's when he got the immunity deal, according to Copeland. Ms. Bumpus. Okay. And when was the last time you talked to him before Melly got involved? Ms. Hilton, we talked to him earlier that day on Thursday. Ms. Bumpus. Okay. And then how did speaks inaudibly to Mr. Copeland? How did he get an immunity? Mr. Copeland. He called me. Mr. Bumpus. Okay. I was just trying to get a timeline. Ms. Hilton. Sure. Right. So we have been talking since last Friday. So I met with Mr. Copeland last Friday, I think out in the neighborhood. Then he came on Tuesday for court. Oh Lord, I'm all the way confused. We talked briefly on Tuesday, and then on Wednesday he came. Mr. Copeland, Thursday. Ms. Hilton, no, I think he only came 2 days. So it had to be Wednesday and Thursday he came. It wasn't Tuesday. It was Wednesday and Thursday that he came. And then on Thursday, once we left, is when Mr. Melnick reached out to us and said, my client is pleading the fifth. And at that point is when we went the next morning and got the immunity motion. So they got the motion, the order to give Copeland immunity on Friday. And then we spoke on Friday morning. I handed Mr. Copeland this agreement and let him know that he has immunity and that anything he says we cannot use. And then Mr. Melnick came, and then we had court. Okay, so then they had court. Okay. So he hadn't testified. Mr. Bumpus, so you are pretty much saying you didn't ask for this, Mr. Copeland. I did, Ms. Hilton, but we gave it. He doesn't have to ask for it. Ms. Bumpus says, I know. I mean, I'm just asking. I'm just saying, right. He doesn't have to ask for it, but to alleviate whatever his concerns were, we gave him immunity. He didn't have to ask for it, Ms. Bumpus. So if he wouldn't have had this, I'm just saying he wouldn't have had this. I'm just saying this so he can understand it. I'm walking him through. Ms. Hilton, Ms. Bumpus, would he still have had to testify, or would he have been able to plead the fifth? That's what he's saying. That's exactly what he was saying. So he feels trapped. He feels like he was led into a trap of this immunity deal, because since he has an immunity deal, he cannot plead the fifth. He still has to testify. They just can't use it against him. And so he was like, I don't want to testify. The immunity deal is like, well, if you testify, anything you say, we can't use against you. And he feels like, but he could have just pled the fifth, and he wouldn't have had to be in an immunity deal. He just would have pled the fifth, and he would have not had to testify. Both things would have been covered under the fifth in his eyes. And so Ms. Bumpus is like, okay, I'm walking him through the process of understanding what puts him in a place where he has to testify. Because now pleading the fifth puts him in jail, because under the immunity deal, he has to testify. And he's saying, well, y'all did this to me. I didn't ask for this. You gave me this immunity. So that's what the whole argument's about. Ms. Hilton, if he did not have immunity, Ms. Bumpus, yes. Ms. Hilton, yes, he could plead the fifth. Correct. He could plead the fifth if he did not have immunity. Mr. Copeland, and Ms. Bumpus, that's what he's trying to say. He's trying to say he didn't ask for this. He didn't ask for the immunity deal. He wanted to plead the fifth. You guys gave this to him, and he didn't understand that. Ms. Hilton, but he doesn't have to ask for it now that we have given it to him, because that's on us. So now that we have given it to him, it's in order. He can still choose if this is the road he wants to take. Then he'll just stay in custody until the trial is over. And when we say the trial is over, every last defendant has been tried, not just these 6, the other ones too. All right, there is the statement. There is the implication that it's not just this trial, it's all the 20 trials, 20 defendants, all of the people in the land that get tried. You have to stay there. So there's the indefinite part to it. There's this no end in sight part to it, unless he testifies. Mr. Copeland, I done did longer time. So, okay. So he's like, I want to do the time. He's not scared about the time. I don't know if he heard all of what she said, but he's not scared so far. It's Hilton. All right. Mr. Copeland, I'm telling you that you are literally immune from prosecution from anything else you may say. That's that. So the choice is always up to you, but we wanted to put on the record. The state does not want you in custody. What the state would like you to do is purge yourself from Mr. Copeland. What purge yourself mean? Yeah, that's not making it plain enough for him. Ms. Hilton, meaning that you are no longer in custody, and the way that you purge yourself is to testify. That is the kind of how it happens. And that is what the state wants you to do. We don't want you in custody. I can't say that any other different way, but we don't want you in custody. The only thing that's holding you is you refusing to testify. Now the court comes in and chimes in. So do you have any questions? Any other questions? Basically, if you invoke the fifth. Mr. Copeland, I don't trust. I don't know what's going on. I don't trust nobody. I don't trust her word, but I don't know what's going on, Your Honor. He doesn't trust her anymore. In his eyes, she hoodwinked him into an immunity deal, which prevents him from pleading the fifth, which he thought he had the right to do, regardless, for whatever reason. And that's why he shouldn't be talking to anybody without his counsel, without his attorney, to explain those types of things to him. Ms. Hilton, this is your insurance. I don't know if you want to break that down to him. Ms. Bumpus, well, he doesn't want that. He doesn't want the immunity. He wants to plead the fifth. Okay, the court, but he's been given it. So this becomes a very slippery slope, Your Honor, because him chiming in right here could be the influencing of a witness. Because right now, the interaction has been attorney and client, prosecution and client, prosecution and client attorney. And so here comes the court weighing in on the subject when he really probably could have just stayed out of it. The court says, but he's been given it. See, that's the challenge, Mr. Copeland, is that if they didn't give you the immunity, you could invoke your Fifth Amendment privilege. But what the state decided is they said your testimony is worth more to them at this point in time, and they really want to know what you have to say. So they have made from the state's perspective, they have made a decision to give you immunity so you no longer can invoke your Fifth Amendment privilege. You have to testify. So did he not agree to the immunity? Doesn't he have to agree to it? It's not like they just give you something and you have to. Well, maybe that's the problem. Maybe they can just give you immunity and make you testify, and in effect take away your Fifth Amendment privilege because they give you immunity. Versus you agree to having immunity. Like you're supposed to agree, you're supposed to sign something. I don't know if it's different here, but anyway. So that's the difference in this particular scenario is that they have taken away, they're taking away your Fifth Amendment right. But he's saying, well, you can still invoke your Fifth Amendment privilege. Yeah, but you go to jail. You still can do that, but the consequences of invoking it is you will just remain in custody till some indefinite long period of time because they can't tell you when all the people are going to be tried and how long they're all going to take. Because this one's already been 2 years. That's probably where Mr. Copeland got his time frame from. He's like, well, it's been 2 years. I can wait 2 years. He's thinking like it's a 2-year trial. No, it's not. So if you testify, you get out of custody and you stay out of custody until you are done. Wait, what? So if you testify, you get out of custody and you stay out of custody until you are done. I don't know. I don't understand that. You stay out of custody until you're done, but you don't go back into custody after you've testified under the immunity deal. You're immune, so you're free. You're free, period. I don't understand that part. All right, Mr. Copeland. And then if I don't testify, I have to stay until when? Exactly. Until when? The court. Until the trial is over. Until all the defendants have been. I mean, I've got these 6 that we have right now, and then there's another 6. No, there's another 12, Ms. Hilton says. The court, there's another 12 or thereabouts that are still outstanding in various forms or another, meaning they're in different stages. So he has 6 right now that's in trial. He probably knows the 6 that are like getting ready to get on trial calendar. And she's like, well, look, but there's a whole 12 other, like, look, you're thinking about 12 in totality, but truthfully, we have another 12 plus the 6. So they're thinking about trying about 18 of these 28 defendants so far. Okay, Mr. Copeland, can I speak with her for a second? The court, yeah, sure. So probably wants to talk to his attorney. So the judge, the assistant, the court reporter, the investigators left chambers at 10:17. So they started at 10:03. I don't know where the deputies are. I guess they left. Well, they don't say that they left. So are the deputies still in there? I don't know. They returned at 10:33. Mr. Copeland, my question is, I can ask you a question? The court, yes. So my question is, so what I was just asking her was, if you ask me a question and you feel as in I was lying about it, you will lock me back up? Ms. Hilton, no. So you are saying you say, I didn't talk to Demikion? Well, no, I can't talk about that because the judge is in here. You are asking, for example, if you said before that the sky was blue and I asked you on the stand, what color is the sky? And you say, I said it was red. I'm going to say no. Back before you said it was blue. Is that what you were trying to ask me? Ms. Bums, So explain the independent evidence. If he says he did something and you know he's not telling the truth, what happens? Ms. Hilton, if he said he did something and he did not do that thing, Ms. Bumpus, if you believe he did not, So if you believe that he's lying about that, Ms. Hilton, then no. If he admits that to doing something on the stand, Ms. Hilton, and he did not do that thing, Ms. Bumpus, Ms. Hilton, I'm going to say, is this the first time you are saying that, Ms. Bumpus? And you have independent evidence to prove it wasn't him, then what? Ms. Hilton, then nothing. What do you mean, like, Ms. Bumpus? So then he will be fine, Ms. Hilton? Yes, but Ms. Bumpus, so you are okay with him if he got on the stand and said things that weren't true? That's ethical violation, by the way. But Ms. Bumpus is really getting into Ms. Hilton. No, I want him to tell the truth. What have I always said to you? I want you to tell the truth. I don't know what's going to come out of your mouth. I expect you to tell the truth. If you say something that is inconsistent with what you said before, then I'm going to ask you about the inconsistencies. I expect you to tell the truth. What you go on the stand and do, I don't know. I don't know what you are going to do. I want you to tell the truth, but I will deal with you not. But I will deal with you not. You saying something different in the manner that I normally do. What? Mr. Copeland, if I'm saying something different, right? So when the police question me, they done question me every time they lock me up. I don't know how many times that was. I done told them whatever different story I could think of to try to finesse my way out of the situation. I don't recall what I done told them. Okay, Ms. Hilton. Okay, so you can say I don't recall. That is how that works. I don't recall, Ms. Bumpus. And he can say that to every single question, Ms. Hilton. I would hope that is not the truth, because I think there are some things you do recall and some things you don't. But the things you don't recall, you don't recall. And then I will go through my process of what I do. You can talk to him about impeachment. You can talk to him about what impeachment is. That won't get you locked up. Impeachment will not get you locked up. You can talk to him about what impeachment is. If he says, I don't recall, Mr. Copeland, what will get me locked up? Ms. Hilton, what did I tell you, Mr. Copeland? I don't know. Ms. Hilton, what you did on Friday? I plead the fifth. If the court instructs you, okay. If the court instructs you, Mr. Copeland, so the only thing that gets me locked up is pleading the fifth, Ms. Bumpus. Yes. Ms. Hilton, the court instructs you. You need to answer the question. You say again, I plead the fifth. Again, that's what's going to get you locked up. Okay, so if the court gives you instruction that you have to answer the question, you plead the fifth again, you get locked up. But if you answer the question, that will not get you locked up. Okay, Mr. Copeland. So if you don't want me in jail, why you just don't let me go after the trial over with? Why I got to stay for all these defendants? Ms. Hilton, you are in jail because you were not answering the questions. The court, because you have been given immunity. Ms. Hilton, because you have been given immunity, you are only in jail because you got up here. Mr. Cohen, well, what about this? I answer the questions. You take away the immunity, I answer the questions, and I plead the fifth. Ms. Hilton, no. Mr. Copeland, two questions that I feel incriminate me. Ms. Hilton, but then that's Mr. Copeland. I won't plead the fifth to things that don't incriminate me. The state can still give you immunity. They can give immunity to whoever they want, okay? And they can make that choice. I don't even make that choice. So if they, like I said earlier, they want your testimony, they figure it's that the jury needs to hear what you have to say, good, bad, or indifferent. And what Ms. Hilton is telling you is just tell the truth as you know it, and let her worry about, even though you may have said different versions of whatever, that's for impeachment. That's not going to get you in trouble. And it's not. Okay. What will get you in trouble is you just invoking your Fifth Amendment privilege because you have been given immunity. Or as Ms. Love said this morning, remember Ms. Love said, if you overtly lie about something, like if you tell a bold-faced whopper, then they can indict you on that particular charge. That particular false statement, Mr. Copeland. That's what we're going to do. Oh my God. Ms. Hilton, that's what I was saying. You will be right back here, Ms. Hilton. But if you say something that you know you did not do, like you admit to something you know you did not do, whether you, like murder don't have like no statute of limitations, right? It's Hilton. But if you didn't do it, I can't charge you with something you didn't do because I don't have any other evidence but you saying it, Mr. Copeland. But y'all don't like, okay, so that's what Miss Bumpers was talking about when she said independent evidence, meaning that just him saying I murdered someone is not enough for them to put him in trial, to charge him, indict him. They would have to have independent evidence that he did it. And the things that he did do that they know that he did already are dead because they have died due to the statute of limitations. It's far exceeded that time frame, so they can't bring those charges up against him. So, but nonetheless, they given him immunity for all charges, full charges, sounds like, as long as he testifies and he tells the truth as he knows the truth. If he doesn't know some parts of the truth, he can say, I don't recall. But he cannot plead the fifth because of the immunity deal that he has, which sounds like they gave it to him and he didn't ask for it. I don't know if he signed it. I'm not sure if he's in agreement with it or they just impose it upon him. That's something that needs to be looked into. I got to figure that out and let you guys know. Okay. Ms. Bumpus, you can charge him with false statements and he will be back in jail. That is what I'm trying to say. So she's trying to get everyone to understand that all this, he's immune from this and immune from that. If he says a lie, he'll go to jail. She's trying to get her client to understand that everyone to be on one accord with that. Ms. Hilton, but if I know that you are lying about that, I do not intend to do that. Well, Mr. Weinstein, I guess you got number 3. We got to pull the bullet points. Mr. Weinstein's 6 assertions based upon affidavit was that Ms. Hilton confirmed that if he lies, she does not intend to put him in jail for it. Line 17, page 41 says, but if I know that you are lying about that, I do not intend to do that. Do that being what? According to Ms. Bumpus, on line 14, you can charge him with false statements and he will be back in jail. That's what I'm trying to say. Ms. Hilton responds, but if I know that you are lying about that, I do not intend to do that. If I know right now he's lying, I know he's lying. I'm not going to charge you because I don't know your reason for doing that. But I'm not going to charge you when I know you didn't do what you were trying to say you did now. And that can be a part of this. I know you didn't do it. Mr. Copeland, but it's up to the judge to do that. Ms. Hilton, no, it's up to the state to bring charges. Or I don't have anything to do with that. Ms. Hilton, he has nothing to do with bringing charges. That's up to the state of Georgia. Mr. Copeland, can I talk to my family? And I will make my decision right after I hang up the phone. Ms. Robbins, he's saying he hasn't been able to talk to anybody. Ms. Hilton, his sister just called us. Mr. Copeland, y'all done me wrong. Y'all just hold me in the jail. Don't let me get no PIN number, no nothing. I don't know what the PIN number is. Ms. Hilton, we have no knowledge. We didn't know that Ms. Bumpus, he hasn't been able to do anything or speak to anyone. Mr. Copeland, the jail system down, but y'all still putting people in. Okay, so I guess whatever internally is going into jail doesn't allow him to make phone calls. Ms. Hilton, that part I don't know. I know we have been in communication with your sister. Your sister actually texted Miss Lansaqua, something, to make sure you were okay. We told her we physically had laid eyes on you. I'll leave that up to the sheriffs. I don't know. So a pause. And so what you think, what's she saying, Ms. Hilton? I can tell you right now, Mr. Copeland, I'm talking about that locking me back up. Ms. Hilton, we would have to bring charges. There would be no incentive. Mr. Copeland, y'all will. Ms. Hilton, we've already had this discussion. Mr. Copeland, look what you did to me. You waited until Friday and you did this. I done told you every day before Friday came that I was pleading the fifth. Ms. Hilton, no, you did not. As a matter of fact, our last report, Mr. Copeland, Copeland, let's see if we can get beyond this, okay? Beyond what your concern is. You could have invoked the fifth privilege. The state could have turned around and said, stop. Had me go ahead and filed the motion and given you immunity. Yeah, so it sounds like the state just filed a motion for immunity without his consent, it seems like. It was going to, I mean, they make that decision. They decided it to make it on Friday. So even if you would have been more comfortable testifying and invoking your Fifth Amendment privilege, they could decide you as a witness, they want your testimony more than they do you invoking your Fifth Amendment privilege, so they gave you immunity. They gave you immunity, so you've got to testify truthfully as to what your knowledge of the particular incident is. I mean, so they could have done that anyway. Even if they put you on the stand, they could have said stop and gone ahead and given you immunity. They could have done that, Mr. Copeland. So I can get in some type of writing that if I was to testify, that if she feels as and I lied about something, that they won't lock me back up the court. Let me have that, Miss Bumpus hands document to the court. Mr. Copeland, on page 2, the order pursuant to OCGA 24. Okay, so yeah, this is the code, Georgia code. However, no testimony given by Copeland has required under this order or any information directly or indirectly derived from the testimony of Copeland given by Copeland as required under this order shall be used against Copeland in any proceeding or prosecution for a crime or offense concerning which he testifies under this order. Okay, so you testify about some aggravated assault or murder. They can't prosecute you on it because that is what it says in the order. Okay, the only thing that will get you in trouble is this next little paragraph. Copeland shall be subject to prosecution or to penalty or forfeiture for any perjury, false swearing, or contempt committed in testifying or failing to testify in accordance with this order. However, it is ordered that Copeland shall not be required to produce evidence that can be used in any other court in this state or the United States or any other state. So basically, if you commit perjury, false swearing, or contempt committed in testifying, that means if you just invoke your Fifth Amendment privilege or failing to testify, you say, I'm not going to testify. All right, so the only two real things you can kind of get in trouble for are perjury and false swearing, as long as you tell the truth. Now, as Ms. Hilton and Ms. Bumpus said earlier, you may have told or been asked about situations over and over again. They may have changed. What the state is asking you to do is tell the version that really is the truth. If they want to impeach you, they can do that. Or if the other side wants to impeach you, they can do that. You won't get in trouble for that. You said I will. The court, you will not. You will not. Impeachment is not perjury or false swearing, okay? Mr. Coleman, but she said I can purge myself, though. So he's confusing purge with perjury. Ms. Hilton, no. We're saying two different things. Sorry. Perjury is if you get on the stand and you say a bold-faced lie, just something that is just wrong. You say, I did something, and all the other times you have said, I have not done it. And really, while it's perjury, it's really just an inconsistent statement. Like you get on the stand and say, I did X, but in 2015, you said, I never did X. That is what I'm going to impeach. I'm going to impeach you on everything you said in 2015, meaning I'm going to say, okay, today you said I did X, but in 2015, Lieutenant Dean enters the room. Lieutenant Dean, we have a security issue. We need to stop for a minute. If we can stop for a second, please. Judge Glanville and Lieutenant Dean exit chambers at 10:45. Judge Glanville return to 10:47. Ms. Hilton, I don't know what was told to you on Friday. I have no reason to want you in prison. You have spent enough time in prison for YSL, period. So why would I want that for you? That doesn't make no sense. I said it to you. Grief, how much longer? I said it to you before, and I will say it to you again in front of all these people. It makes no sense. Mr. Cole, you just said I'm going to have to stay in jail until the last. Right. Ms. Hilton, if you don't testify, get this part through your head. If you don't testify, that is the only thing that is holding you. That is literally the only thing holding you right now is the fact you keep saying, I'm not going to testify. Well, you haven't said it today. I'm not testifying. I plead the fifth. If you get up there and I want you to tell the truth. Like I said before, if you don't recall certain things, you can say you don't recall. That's fine. I want you to tell the truth. I don't expect you to remember every single detail from 2015. I just don't. No one here does. But what I do expect for you to do is answer questions so we can get through this, so you can go home, be with your baby for her birthday, see these dogs deliver their babies, go talk to your nephews and do all things. She know a whole lot about his life, don't she? Mr. Copeland, how you know about my dogs? Well, I'm like, I know about Ms. Hilton because you told me. Oh, okay. Ms. Bumpus, what's wrong? Ms. Hilton, I'm stressing at another level. Like, I mean, I'm saying, Mr. Copeland, I'm weak, man. I'm not playing. I'm dead serious, man. Like, Ms. Hilton, this is what our position is. We do not want him to in custody. We want him to tell the truth. We want him to testify. That's what will get him out of jail. And you know you have to make Ms. Bumpus, if he decides in 2 weeks he wants to testify, then what? Ms. Hilton, if he decides to stay in jail for 2 weeks, then that's, I don't know why you would want to stay in jail for 2 weeks. I have no idea. Ms. Bumpus, he just feels like he's under a lot of pressure right this second. Mr. Copeland, even at the jail, they are just, you can't give me house arrest. Ms. Hilton, no, you can go home by taking the stand and testifying. That's what the court, and come back tomorrow. Ms. Hilton, we keep on saying yet, but there is no crime. Yeah, so something's missing. I feel like something's missing from this contextually. And I know we're doing these pauses and these supposed 1 minute breaks, and there's like this 20-minute break or something. But here we get into Ms. Hilton saying, we keep saying yet. I haven't read the word yet anywhere in here. I haven't heard yet. So what are we talking about yet? We keep on saying yet, but there is no crime. We keep on saying yet. I don't know who is telling you about a crime. There is no crime. You have done nothing wrong except for not, Mr. Copeland. So why am I in jail then? Because you aren't testifying, Mr. Copeland. But that ain't nothing wrong. It's not a crime. Ms. Hilton, it's not a crime, but you're in civil contempt. The court, 2 things. Because you invoked your privilege after you have been given immunity, that is why you are in custody. Because you get out by testifying. So you testify, you get out. That's why I was going to bring you, why I brought you here early today, to just inquire about that. You can remain and hold your position of invoking the 5th or not testifying, but you go back to prison. You go back to jail, because you can't sentence me, Miss Bumpus. There's no sentence. The court, there is no sentence. The contempt is compliance. They want your testimony. That is all they want, whatever that may be. Mr. Coleman, I don't know what it is, Your Honor. Hilton, so listen. You're in jail for failing to testify, the court failing to testify. Ms. Hilton, not for nothing else. There is no crime. You haven't done anything wrong. I can't say that. You ain't done nothing. You ain't done nothing. I don't know if people are telling you that we are going to charge you with nothing. You are not charged. We are not charging you. The state charges you. There is nothing we're charging you with. You are only in custody because you have decided not to testify. That is it. Once you decide to testify. The court. Remember that word you were talking about, purge, Copeland? The court. Okay, you can purge right now. Purge, get yourself out of jail just by testifying. Mr. Copeland, I can purge and get out of jail. The court, yes, just by testifying. Miss Hilton, not perjury. Court, purge, meaning you can get out of jail. You can get out of jail, out of custody just by testifying, Mr. Copeland. And what about the other one? The other word, perjury. That's different. Miss Hilton, that's different. The court, that's a different word, okay? Mr. Copeland, that can get me back in jail. Miss Hilton, yes. Perjury is, Miss Hilton, it's not what you are saying is not. Well, why would you cut the cord off? What the heck? I don't know. Would she really cut the cord off to explain perjury? Or are we erasing words here? Miss Hilton, it's not, what you are saying is not perjury. What you are saying is what we call a prior inconsistent statement. Your example that you gave me, what if I said I did something and I know you didn't do it, and you said before you didn't do it? That's not perjury. That is a prior inconsistent statement. Hey, Ms. Bumpus, you've got to make a decision. So if he starts testifying today, he's going to go home today. Ms. Hilton, he should, so long as he remains. But if you get up there and be like, if you get to testifying and then you get into it and you start saying, I plead the 5th, we're going to be back here again. Ms. Bumpus. But if he says he doesn't recall to anything or everything, he'll be okay. And so I'm not advising that, but so long as he answers the question, that's fine. So long as Mr. Copeland, I did these crimes. I'm telling you that. And boom goes the dynamite. Mr. Copeland, I did these crimes. I'm telling you that. Miss Hilton. Okay, I don't know what you're talking about, but Miss Bumpus, I think, are you saying you want to get up there on the stand and say something? Mr. Copeland, no response. Ms. Bumpus, did we find out if he could talk to his family? No? There's a brief pause. Ms. Hilton, I mean, if it's okay, we got the sister's number. Mr. Copeland, as my attorney, you gotta, Miss Hilton, if y'all want to talk, let me go somewhere where I can't hear you. The judge is over there, so just speak low so he doesn't hear you. Court, hold on. Judge Glanville handed a document to Attorney Bumpus and exited the chambers with Assistant Hilton, investigators Long and Hamilton, court reporter. For 30 minutes, I guess. The court. Okay, all right. Mr. Coleman, have you had an opportunity to talk with Ms. Bumpus? You're a lawyer. And Ms. Hilton, the state's counsel. Have you got any other questions? Mr. Hilton, no, Your Honor. The court. Is it your desire to give testimony today? Yes, Your Honor. The court. Okay, all right then. Do you all have some clothes for him, Ms. Hilton? I don't know. Let me go look. What size are you? I can't hear you. What size? Little. Investigator Hamilton. We had a large jacket for him on Friday. Large. Miss Hilton, you had a jacket for him? Investigator, yes. Oh, but he can't wear a large? The court, what is your waist size? 34, Mr. Copeland. 32, chest, 34, 36, not my chest, size and small and medium. They're going to try to get you some clothes. Okay. You don't have to, so you don't have to testify wearing that jail uniform? Okay. Y'all don't want to show the people how y'all did me. Mr. Copeland, y'all don't want to show the people how y'all did me. The court, look, Ms. Hilton, if we can't find clothes, then you may have to until tomorrow. Mr. Copeland, I prefer to go in like this. Ms. Hilton, I understand what your preference is. Nah, don't hide it. Can you make him put on clothes, Ms. Pumpus? Oh, Ms. Moore, can you make him put on clothes? Ms. Hilton, no. Mr. Copeland, I want to go in there like this. Ms. Hilton, fine with me. The court, all right, okay, Mr. Copeland, you ain't gonna try to lock me back up for this. Ms. Hilton, so long as you testify, we will get in order to get you released. Today, Ms. Bumpus asked the court, whose copy is this, Ms. Hilton? You've got to make sure you come back now. I want to be real clear, Mr. Copeland. When have I ever ran? Ms. Hilton, you have not. That's the only thing you have not. Whose copy is this? Says the court. Ms. Hilton, that was yours. Do you want a copy? You can take it though. Okay. Ms. Bumpus, okay, Ms. Hilton, do you still have yours or you threw it away? I'm going to give him both of these things so he can have some information. Ms. Hilton, okay, are we off the record now, court reporter? Are we done from the court? Ms. Bumps, yes, I believe so. The court, okay, we're good. See everybody downstairs in about 10 minutes. Proceedings concluded 11:31. 11:31, from 9:10 to 11:31. So it was even longer than the defendant said. We found a couple places. I don't know. I feel like there's some missing information. I don't know if it's artfully missing because maybe conversation was had off the record because there was a couple of breaks and recesses, but there's also this point of we keep saying the word yet, and there's nowhere in the transcript. Let's just see. Let's prove to ourselves. Maybe it's me. Maybe I'm the one who's doing it wrong. Control F, Y, E, T. Where you go? Oh wait, can't see. Everything's in the way. The word yet's not coming into play at all. So, okay, so it's not working. So we should at least have it one time because we saw the word Y. So Y comes up 6 times. What is on this one page? You're only looking at this one page? They're only looking at the one page. Okay. It's a very weird. Let's see if we can fix that. Hold on. Let me see if I can make this better. Just kidding. As a print it. PDF. everything you PDF or save is searchable. This would be a searchable document. Found it. Where'd it go? Where'd it go? Where'd it go? Okay, hold on. Let's try it again. Oh, there was an error opening the document. Won't let me PDF the document. Wasn't that wonderful? Here we go. With search the word. Let's see if I want to read only. Okay, it's not working. Not working. Not working. Let's forget it. Okay, okay. Forget it. I'm gonna have to look. Just hold on 1 second, and I'll be right back. Okay, so I'm back. I cannot find any other place that I can get a searchable document. So if we ever get a searchable document, we can probably revisit that at a later time. Bottom line is, when it comes down to Mr. Copeland and the ex-parte hearing, he was given immunity. Oh, we should be looking at that. He was given immunity, and they did it pursuant to Georgia Code Section 245-507. And he didn't ask for the immunity. It's almost as if they gave it to him as a motion. So it's not necessarily an immunity deal because he didn't deal it, I guess. Let's see. Can one be given an immunity as a motion to require testimony? Because it's almost as if they're taking his Fifth Amendment privilege away. So, according to U.S. Court of Appeals, the government may compel a witness to testify under a grant of use of immunity contrary to the witness's Fifth Amendment privilege against self-incrimination. So, okay, so yeah, but that's really not what I want to know. Okay, so you guys have to educate me this time. You got to tell me what's the truth. Does the immunity deal have to be signed by the defendant? Or the witness? Can the immunity be unilateral in that regard? Can the prosecution just decide the immunity is in place without the actual witness agreeing to it? I want to know that. That's what I want. So if you know, put it in the chat and let me know. If now I'm finding about former president's immunity deal and ask about that. Really didn't ask about that. Yeah, it's not coming up. So let me know. Can the immunity deal be unilateral? So this one says a grant of immunity is a unilateral act. Okay. Yes, sir. Like I say, I practice civil law and business law and defense for civil business issues. I don't deal with criminal. It's interesting to know that the immunity deal can be unilaterally set upon whether you ask for it or not, which takes your right to invoke the Fifth Amendment privilege, requires your testimony. And if you don't testify, you can get arrested for breaking the immunity deal for which you didn't ask for in the first place. Okay. He must have to sign it. I just don't understand how you can invoke someone to an agreement to where if they don't maintain the clauses of the agreement, paragraphs, and they don't do as the agreement says they're going to do, that you can arrest them, that you can find them liable in any kind of way. That I just don't know. That unilateral immunity, I thought immunity had to be an agreed upon exchange. But interesting enough, we find out that they gave him immunity somewhere as he was going to jail, according to him. And he said he was pleading the fifth on Thursday evening is when his attorney told them. And he proclaims that he told them Tuesday, Wednesday, and Thursday that he was pleading the fifth. Ms. Hilton says he didn't say that, but she responds in a way where she kind of knows that they talked about pleading the fifth, because she supposedly says, her response is, well, why would you plead the fifth to something you didn't do? Then we have this section of the transcript that looks like it's referring to conversations not on the record for some reason, whether that section is taken off the transcript or it's during a recess or it's some other conversation where it's like, well, I wouldn't prosecute you for that. So, I'm not going to prosecute you for that because you didn't do that. So I'm not going to prosecute you for that. And then we get to where he says, I'm trying to tell you, I'm the one who did all these crimes. I did those things. I'm the one. And she's like, no, you have to go on, but you do have to go on stand and tell the truth. So I don't know what Brian Steele and the rest of the defendants, Weinstein and all of the other defendant attorneys are going to do. But there is a lot going on right here that even with that little bit of the transcript where I wouldn't prosecute him for false statements. I would just, or inconsistent statements. I would just note his false statement as an inconsistent statement based upon what he said before, and I would impeach him. So her whole goal is I will impeach him on it, but I'm not going to prosecute him for false statements. I will note it as an inconsistent statement to a prior statement and impeach him based on that. And then when the question comes up, well, I'm the one who did all these crimes. No, we're not dealing with that. Just need you to testify. We testify truthfully. So I think there's a lot left out of this conversation relative to this transcript. It doesn't really align with much. So it will be very interesting to hear what Ms. Bumpus has to say relative to, does this transcript have the full information? Ms. Bumpus did say that she never heard her client admit to killing Mr. Donovan. So she does say that. Ms. Bumpus said that. She does not recall that being a statement of his. Nevertheless, there is clearly a part of the transcript where he says he's the one who committed these crimes. And the response is, I don't know what you're talking about, versus what crimes did you commit? It's almost as if you don't want to hear the crimes. And it may be just that he is trying to say, I'm the one who did everything you're trying to say that these guys did. I'm the one who did it. So, I don't know. Take it with it as you will. Put it in the chat how you feel. And then let me know about this immunity unilateral deal. Like, how does this work? I have problems, questions and more questions and problems and more problems. Let's all make it plain. Put it in the chat, help everybody out. Let's learn together. All right. Lyric Armstrong, real estate agent and advocate. Have a good one and happy 4th of July to all those who are in America.